morning, everyone. If you could please take your seats, we're just ready to begin.
Welcome to the Honourable Côté Symposium. My name is Lydia Roseman, and this is Landon Haynes, and we are the co-editors-in-chief of the Alberta Law Review. It is a privilege for us to be here to act as your Emcees for the day.
Before we do begin, there's just a few housekeeping items that we'd like to go through. To commemorate this event, the panel discussions will be published in an upcoming issue of the Alberta Law Review. This symposium is being recorded, and please also note that photographs will be taken throughout the symposium. There will be a refreshment break at 10:30 that will take place in the hallway just outside this room, McLennan Ross Hall. If you notice volunteers, you'll notice volunteers guiding you back into the room after the break. Lunch will also be available in the same room. Washrooms are also located on the first floor. And I think that takes care of all the details.
The University of Alberta acknowledges that we are located on Treaty 6 territory and respects the histories, languages, and cultures of First Nations, Métis, Inuit, and all First Peoples whose presence continues to enrich our vibrant community.
So we begin this symposium with a brief welcome from the Faculty of Law's Dean Paul Paton. Dean Paton was appointed Dean of Law and Wilbur P. Bauer Professor of Law at the University of Alberta Faculty of Law in July 2014. An expert on legal ethics, professional responsibility, the regulation of lawyers, and corporate governance, he has written and spoken extensively on these issues and has been recognized for his work in the United States, Canada, and England. His prior academic achievements are extensive, including as inaugural Vice Provost at the University of the Pacific in California. Prior to entering the academy full-time, he practiced for a decade as a commercial litigation partner, as an in-house counsel to PricewaterhouseCoopers, and as justice and social policy advisor to the Premier of Ontario. Ladies and gentlemen, Dean Paton.
Thank you very much, Lydia and Landon, and good morning, everyone. Justice Brown, Chief Justice Fraser, Chancellor Stollery, members of the Cote family, distinguished guests, students, faculty, friends, colleagues, Justice Cote and Mrs. Cote. As Dean of the Faculty of Law, I've been invited to bring greetings on behalf of the faculty and to offer a welcome and some opening remarks on this very special occasion, the celebration of the Honourable Justice Jean Cote and his legal and judicial career, and, quite relatedly, of the honorary degree he received in November 2017 from the University of Alberta. As you're likely aware, the Faculty of Law awards the overwhelming majority of its degrees at graduation ceremonies in June, and so regrettably, our graduates did not have the opportunity to hear from Justice Cote on that November occasion. Today we get a chance to correct that a little bit, and as you'll hear shortly, as well as had a chance to hear from a number of our faculty and former faculty, a discussion of Justice Cote's contributions to the law and legal scholarship are important to this faculty, to this university, to this province, and to the country. Today's celebration is the latest in a series of busy and important events at the faculty, and I thought the juxtaposition was quite interesting. 2 weeks ago, working with student leaders from the Law and Business Association, we hosted the second annual Law and Innovation Conference. That conference has attracted speakers from all over North America and has endeavored to look ahead to the future, to explore what technology and innovation might do to transform what we practice and how. Today's event takes a different lens, offering instead the chance to look at our history, guided by local experts, and focused on the career of someone whose life in the law, like so many eminent graduates of this faculty, is centered on this city and this province. Indeed, during my time as Dean, I've encouraged the faculty to celebrate our graduates who have gone on to become distinguished members of the bench, something that you can look forward to in a cover story in our alumni magazine this spring. Also in that vein, today also marks our first public opportunity to celebrate the news only yesterday that graduate, longtime sessional instructor, and great friend of the faculty, the Honourable Mr. Justice Kevin Feehan, has been elevated to the Court of Appeal. I offer on behalf of the faculty our sincere congratulations to Justice Feehan and to the Court. While I've been able to move many projects forward during my nearly 5 years as Dean, unfortunately I was unable to garner the requisite support for a judicial honourable, so let me plant that seed again today. In so many faculties of law, There is a judicial honor wall celebrating the achievements of graduates who have gone on to serve with distinction on the bench. It's an important and necessary tradition, allowing a visual representation of Justice Cote and so many others, Chief Justice Fraser, Chief Justice McLaughlin, who have served the courts and indeed the people of Alberta and Canada with such distinction. That will be for my successor. As you'll hear over the course of the morning, during 28 years on the Court of Appeal, Justice Cote delivered a remarkable number of judgments, while also playing a critical role in setting the rules for Alberta's justice system as a longtime member of the Rules of Court Committee, a multi-year project led by the Alberta Law Reform Institute to make the rules clear, usable, and effective. Justice Cote received the Horace Harvey Gold Medal as the graduating student with the highest academic standing in the faculty in his graduating year. And while his achievements in class were obviously exceptional, it was his work as an editor of the Alberta Law Review that many point to as having laid the foundation for his future work, about which you'll hear a lot more shortly. From the Faculty of Law, he went to the University of Oxford for his BCL, graduating with first-class standing. He became one of the first 5 clerks of the Supreme Court of Canada, clerking for the Honourable Justice Ronald Martin, only the second Albertan appointed to the court. He then spent 20 years in private practice in Edmonton before being appointed to the Court of Appeal of Alberta and of the Northwest Territories in Nunavut. As I noted a little earlier, a little more than a year ago, Justice Cote received an honorary degree from the University of Alberta. And as Chancellor Doug Stollery noted at the time, honorary degrees celebrate individuals who have had a transformative impact in a chosen profession and are an outstanding example of leadership and service to Canadian society. Before his degree was confirmed, Chief Justice Fraser introduced him, drawing attention to what she identified as his powerful and enduring judgments, his humanity and compassion, and his service throughout his career as a faithful sentinel for the rule of law. It was, of course, impossible in the context of that occasion to cover in any significant detail the breadth of his contributions to tort law, to civil procedure, to contract and construction law through his judgments, his research and writing, and his service to this faculty. A remarkable array of panelists, fortunately, including former faculty members, the Honourable Justice Russell Brown of the Supreme Court of Canada, the Honourable Justice June Ross of the Court of Queen's Bench of Alberta, and others will help us reflect on Justice Cote's influence in several vital areas of the law. Specifically, Justice Brown and Professor Annalise Acorn will reflect on Justice Cote's contributions to tort law. Justice Ross and Professor Barbara Billingsley will focus on the contributions Justice Cote has made to civil procedure. Professor David Percy, who will take over as interim dean when I finish my term in June, and Chancellor Stollery, former General Counsel to PCL Construction, will speak to Justice Cote's contributions to contract and construction law, respectively. University of Manitoba former Dean of Law, Professor Emeritus Trevor Anderson, will throw open a window to an era that few know as well as he does, that of Jean Cote, law student. The co-editors-in-chief of the Alberta Law Review will mark today, with a special occasion, an honorary editorship on Justice Cote. And I'm especially pleased that the Law Review is publishing the proceedings in the tradition of a festschrift. When Professor Acorn first approached me for financial support for a research student and other financial support for assistance in preparing the symposium of the day, I was pleased to grant it immediately, and I asked whether the Law Review would be involved, knowing how important the Law Review was to Justices Cote and especially Justice Stevenson as well, and what an opportunity an occasion like this would provide our students to work with the authors. Students have heard me on a number of topics throughout my deanship as somewhat of a broken record, but this is what I'm proud of. There are 3 activities I've noted consistently unique to the law school experience: mooting, SLS, and the Law Review. Our Law Review ranks have produced clerks to all 3 levels of court in this province and to the Supreme Court of Canada, and have populated the profession, the judiciary, and the faculties across Canada, across North America, and indeed the world with distinction. Though the Law Review has separated financially from the faculty, it remains an important co-curricular learning experience that I've been particularly proud to support. Lydia and Landon, I congratulate you on your efforts today and in what will become an important volume. I also want to thank our staff who have been working hard behind the scenes to make this event happen. Our communications team, including Director of Communications Tara Blasco-Rye, Sarah Foe, Priscilla Pop, Helen Matella, and Tim Young, Assistant Director of Advancement Gillian Reed, and special thanks to Alex McKenzie from the Alberta Law Review, who led the program efforts. Thank you all very much indeed for joining us for an important day. To begin today's program, I now have the privilege of welcoming the Chief Justice of Alberta, the Honourable Catherine Fraser. Chief Justice Fraser graduated from this faculty in 1970 as the silver medalist. This may be one of the last occasions I get a chance to do this publicly, so let me wax on a little eloquent if you don't mind. She graduated as the silver medalist and received her Master of Laws from the London School of Economics and Political Science in 1972. She was admitted to the Alberta Bar in 1971, appointed Queen's Counsel in 1983. Prior to her appointment to the Court of Queen's Bench in 1989, she practiced law in Edmonton, concentrating on corporate and commercial law, and also served as chair of the Alberta Public Service Employee Relations Board. She was elevated to the Court of Appeal in 1991 and appointed Chief Justice of Alberta and Chief Justice of the Northwest Territories Court of Appeal the following year, the first female Chief Justice of any province in Canada. On the creation of Nunavut in 1999, she was appointed Chief Justice of the Nunavut Court of Appeal. Chief Justice Fraser's list of accomplishments are lengthy, and I won't go through all of them. But I note that she's been a member of the Canadian Judicial Council since her appointment as Chief Justice in 1992 and has served in many roles. Chair of the Council's Education Committee, she's been a member of the Board of Governors for the National Judicial Institute, she's a recipient of the 2014 Lifetime Achievement Award from the Women in Law Leadership Will Awards. She's also the recipient of Honorary Doctorates of Law from the University of Alberta in 2013, the University of Windsor in 2012, the University of Calgary in 2007, and the University of Lethbridge in 2006. Over the past 2 decades, Chief Justice Fraser has advocated for the rule of law, judicial independence, and human rights internationally, topics that have never been more important. She's been involved in judicial education initiatives in Australia, New Zealand, England, India, Pakistan, Sri Lanka, Serbia, Croatia, Taiwan, Zimbabwe, and I know I've left a few off that list. She's worked with judges from many of these countries and spoken and written on a wide range of topics. And most notably, she's been steadfast and vocal in her commitment to the rule of law, constitutionalism, access to equal justice, and the protection of rights and freedoms for all individuals. I encourage you to have a look at her powerful message on the Alberta Court's website, but let me quote from a small portion of it. And I quote, "Defending the rule of law is a duty and challenge for the judiciary. We cannot fail. This requires credible knowledge and understanding of both the law and people. If the judiciary is to maintain its integral role in the delivery of justice, we ourselves must meet justice's highest standard. That means an impartial, informed, open-minded judiciary, respectful of change when warranted, and resistant to change when capricious. Our citizens expect and deserve no less." Here to help introduce and celebrate the contributions of her former judicial colleague and friend, please join me in welcoming one of this faculty's most distinguished graduates, its great friend and supporter, the Honourable Chief Justice Catherine Fraser.
Good morning, everyone. And before I begin, I just want to be sure that everyone can hear me easily without any problem with that. And thank you all for being here. I know that we're competing with never law rehearsals and other things that are going on this morning, so I'm pleased that you're all able to attend this seminar in honor of my friend and former colleague, Justice the Honourable Cote. On August 14, 1940, a gorgeous Edmonton summer day, a baby boy was born in the old Misericordia Hospital and quickly baptized. Whether it was because he was ill, we do not know. What we do know now is that this baby, christened Jean-Edouard Léon Côté, was destined for greatness and would go on to become one of this country's true judicial giants. According to Jean, my maternal grandmother, Cecile Côté, opened a bottle of champagne to celebrate my birth. She had kept that champagne upright for years, not realizing it needed to be stored sideways. So when she opened it, it had lost its fizz. That's the story of my life. No fizz. Au contraire. The record proves beyond a reasonable doubt that in his service to Canadians, the Honourable Jean Côté achieved the gold standard of excellence. Indeed, he is the gold standard. As a brilliant legal scholar and one of this country's leading jurists, Jean represents the best the legal profession can produce. His intellect is superior, his work ethic incomparable, and his service record sterling. Altogether, that has meant a lot of fizziness along the way. How appropriate that his alma mater, to which Jean has brought great honor and distinction, has seen fit to confer on him an honorary doctorate of laws. Jean is a direct descendant of Jean Cote, who sailed from Dieppe in May 1634 to Quebec. Fast forward 200 plus years, Jean's grandfather, Jean-Léon Côté, his namesake, was working in the Yukon as a surveyor. As the gold rush was winding down, he analyzed where the best place to live in Canada would be. He decided Edmonton was the logical choice based on Alberta's natural resources and, don't laugh, the weather. Settling in Edmonton, he married Jean's grandmother, Cecile, and they had one child, Jean's father, Jean-Gustave Cote. When Jean's grandfather died young, Jean's father left school to help support the family. He became a stenographer for the Canadian National Railway and married a young librarian, Cecilia Taylor. While Jean's parents did not have a lot of money, what they did have were strong values they impressed on Jean, and these were values that he has carried with him throughout his life: integrity, hard work, commitment to family, love of learning, and devotion to duty. One Sunday afternoon, George Steer Casey invited Jean's grandmother, Cecile, for tea. Cecile asked her house guest, Chief Justice Rehnfeld of the Supreme Court of Canada, whom she had known from her early days in Quebec City, could join her. The answer, of course. When they arrived at the Steer residence, the Steer's dog bit the Chief Justice. It is claimed that from that incident was born the principle that every dog is entitled to one free bite. Jean excelled as a student, quelle surprise. From the time he was in grade 6, he wanted to be a lawyer. His course set on law, Jean attacked the challenges ahead with his trademark zeal. As a classmate said, Jean was the only high school student who carried a briefcase and at speed. He never strolled anywhere. It was like watching John Cleese from Monty Python, you know what I mean. He was going like this. After graduating from grade 12, it was off to McGill, where Jean earned a BA honors in economics and political science, graduating at the top of his class. The Montreal newspaper published a photo of him as top student. According to Jean, the CNR vice president asked me to pay him a visit. He offered me a job. I thanked him and told him I had decided to go to law school. So law school it was, back home here in Edmonton in the U of A. Jean has many qualities that marked him for success. His astonishing memory is certainly one of them, not to mention his incredibly inquisitive mind. People are constantly mystified at the breadth of what he has absorbed, cataloged, and cross-referenced. Couple this with Jean's near-perfect recall, and it's easy to see why he excelled at law school. One day in Tort's class, Dean Wilbur Balker started talking about a certain obscure poem. He wheeled around, pointed at Jean, and jokingly said, "And what's the rest of it?" Jean then proceeded to recite the balance of the poem from memory. From that moment on, rumors spread that Jean had memorized the entire Encyclopedia Britannica, which may not be familiar to some of you. No one was surprised when Jean graduated with the Horace Hardy Gold Medal. He then left for Oxford, where he earned a bachelor in civil law, again top of his class, so 3 degrees, 3 firsts. Returning to Edmonton, Jean articled to Bill Herbert QC at Herbert Reynolds. According to Sonny Mirth QC, Jean was thorough, exacting, incredibly knowledgeable in everything he did. A nerd. He's probably one of the few people alive who uses Pitfield standardized shorthand. He could take notes as quickly as a court reporter. I just have to pause here and tell you another thing about him. He types with one finger because he insists, well, 2 fingers, that if you could type faster that way than with the 5 fingers. And sitting in the back room when we were doing up a judgment and he was going like this with his fingers, I can attest to the fact that he could do it incredibly quickly. So partway through his articles, Justice Ronald Martland asked Jean to clerk for him in the Supreme Court. After doing so, Jean returned to Edmonton and was admitted to the bar. With his work ethic and unparalleled knowledge of the law, he soon carved out a reputation as a highly skilled commercial litigator. As Rob Grasser, now on the QB, said, working with Jean was like working with Halsbury's. There was a well-worn path to his office, beaten by colleagues asking for his assistance. No one wanted to be up against Jean. He is nothing if not organized, incredibly organized. And like one of his favorite authors, Sherlock Holmes, he has always been interested in the psychology of law. Keith Ritter, who became Jean's colleague on the Court of Appeal, learned a lot about this subject while in private practice with Jean. In December one year, Keith went into Jean's office and saw him bundling up Christmas presents with beautiful red bows. Keith asked Jean what the presents were for. Jean's answer, they're all statements of claim. At Christmas, people will accept anything with a bow. In the 105-year history of the Court of Appeal, only a few lawyers have ever been appointed directly to this court. Jean Cote is one of them. In his 28 years on the court, he had a hand in virtually every aspect of the court's work. Court procedures, practices, list management, case management, strategic planning, rules of court, articling students, mentoring, you name it, Jean did it all extraordinarily well. And when it came to our primary duty, deciding cases, Jean was in a league all his own. Look, it's really difficult for me to do justice to Jean's contribution as a judgment writer. With his knowledge of the law, his encyclopedic knowledge, he always seemed to know if a point of law had been decided anywhere in the common law world, and if so, where. The prodigious quantity of his work, he wrote almost 1,700 judgments, was matched by its exceptional quality. He wrote leading judgments in all areas of the law. You will shortly hear about his contributions in tort law, civil procedure, and contract law, but I would like to explain the larger context of his life's work this way. Jean's mission has been to do justice in accordance with the rule of law. This invisible force protects everything that we enjoy in life. Law and facts collide, people and interests are in conflict. Judges must try to make sense of it all. Jean's approach to judging reflected a deep understanding of the limits of the appellate role, the vital importance of stability in the law, and above all, that as a matter of logic and policy, the law in a given area should all fit together. While Jean deeply respects the art of legal history, he's never been a hostage to it. Rather, he saw the wisdom of our predecessors as a basis on which to build up the rights and freedoms of individuals in modern society. His judgments have touched the lives of everyone here today. In tort law, Jean did his best to rationalize disparate theories on where tort law should be going, and he exercised caution in defining both the relationships that give rise to a duty of care and how far to throw the foreseeability net. In civil procedure, Jean towered over the evolution of the law. As chair of the Rules of Court Committee, for almost 2 decades, he understood very well that the rules are merely a means to an end. In other words, litigants should not be able to use the rules to delay dealing with the substance of the case. As for contract law, Jean understood that subject to defined limits, freedom of contract does remain a key principle of the common law. His judgments underscored the importance of certainty and the strong policy reasons for allowing contracting parties, especially in commercial matters, to set the terms governing their relationship. In constitutional law, Jean recognized that division of powers means just that. Power is divided, and provinces actually have some powers into which the federal government cannot properly intrude. And that the Charter protects not only certain individual rights, but other rights too, including equality rights. And that when rights collide, one right does not automatically trump another. Jean has also had a strong influence in criminal law and sentencing. His sentencing judgments, grounded in Parliament's overarching sentencing principle and rejection of the unfairness sometimes involved in judge shopping, often delve deeply into where to draw the proper line in sentencing and why. Colleague Jack Watson put it best. Jean was meticulously engaged in getting the law right. He knew that the more persuasive the common law is, the more impact it has. And as an appellate judge, he wanted to say something that the people of Canada could not only believe, but believe in. As for his writing style, no one writes in Jean's voice. It's highly distinctive, clear, concise, and colorful, and packed with reasoning grounded in logic. As in, if this, then that, and if that, then a problem, and a big one, and so I'm not going there. As Justice Franz Slatter has said, you always know when you've got a Côté judgment. It's like looking at a Picasso. There's never any doubt about who the artist was. Jean's judgments are replete with similes, metaphors, allusions, and logic examples to which everyone can relate. They reflect his key point about legal writing. If you can't explain your argument to your next-door neighbor, you don't understand your own argument. So to ensure the reader understood what he was saying, Jean used colorful turns of phrase which link legal principles to a diverse array of objects, events, and creatures. Backwards reasonings, cat's paws, and especially dog's tails. I love dogs. I think Jean must have a special place for them too, because dogs always figured prominently in Jean's judgment. Examples, here the tail wags the dog, or the tail may do more than wag the dog. It may be chasing the dog in circles. Or the tail is not only wagging the dog, but it's growing larger than the dog. In one case, when a person claimed to have spent $269,000 in 1 year on intangibles without any evidence, Jean wrote, well, that average is over $730 a day every day of every week. No man's bar tabs, restaurant bills, or opera tickets can steadily come to that, even if washed down with Veuve Clicquot. In another case, a telecommunications company argued it should be entitled to charge for a 911 service in the North, even though it provided none. Jean wrote, it's like delivering to a starving person a photograph of a turkey dinner and then charging him or her for the turkey dinner. Jean's questioning style in court can be summed up in 6 words. Let me give you an example. As the master of the hypothetical, the minute Jean leaned back, put his hands together in a teepee and said, okay, counsel, let's suppose that. Counsel knew they were in for a true challenge. By the time Jean got through everything he wanted them to assume in answering his question, probing the logic of their reasoning, they sometimes lost their train of thought. I must confess that by the time Jean, with his beautiful mind, finished with his assumptions, we, his colleagues on the panel, sometimes lost ours too. Jean is a born teacher. From the time he was a young lawyer to this day, he has taught and mentored generations of lawyers, students, and judges. And I believe one reason he's so successful is that he's a master of trivia. He knows so much about so many subjects, economics, geography, politics, history, and movies. He realizes that to understand the future, one must know the past. He's an expert on military history and an unrivaled film buff. Ernest Hemingway once said, for a true writer, each book should be a new beginning where he tries again for something that is beyond attainment. He should always try for something that has never been done or that others have tried and failed. Then sometimes, with great luck, he will succeed. By this standard, Jean has succeeded 8 straight times. His legacy includes the first modern Canadian text on the law of contracts written when he was just a young lawyer. and he's perhaps best known for co-authoring, along with his longtime friend Bill Stevenson, the Civil Procedure Encyclopedia, known as Stevenson and Cote. The current edition consists of 82 chapters in 5 volumes, listing over 39,000 judgments and referencing 80,000 or more citations from texts and articles. And he has written 2 of the only books in Canada on appellate judging. To give you some idea of his dedication, his most recently published book, Words That Bind, took Jean over 40 years to write and contains some 32,000 entries. It has been my great privilege to have worked closely with the Honourable Jean Côté for almost a quarter of a century. During his time on the appeal court, Jean never lost his enthusiasm for his work, not once. He ran full speed through the tape at the finish line, issuing his last judgment on his last day as a sitting judge. Please join me in thanking the Honourable Jean Côté, an extraordinary judge, an extraordinary person, for his formidable, faithful, and fearless service to the people of Canada and to justice for all.
Thank you, Chief Justice Fraser. It is now our pleasure to introduce a screening of the Honourable Jean Côté's speech to the University of Alberta graduates at the November 2017 Convocation ceremony when he received an honorary degree. In his speech, the Honourable Jean Côté provided a valuable message to students, which all of us in this room currently are or have been. He reminded us to be grateful to our teachers and to honor their contributions. While it is important to take ownership of our successes, it is just as important to remember that we do not learn in isolation. It is our professors who create the learning environment, author the textbooks, and shape our discussions.
When I watched the address, what really resonated with me was Jean Côté's call for the community to not only seek out knowledge and learning, but also to develop the environments and structures to effectively distribute that knowledge. I believe we should heed his call. To all the law students here today, I encourage you, as I'm sure the Honourable Jean Côté would, to actively seek out opportunities that allow you to share your knowledge with others, whether that be writing papers, speaking at conferences, or becoming sessional instructors. As he says in his speech, the richness of society depends on the community's ability to transmit knowledge. Now please enjoy the convocation speech.
Eminent Chancellor, Mr. President, Mr. Chairman, distinguished members of the Academy, honored guests, and eminent graduates. A quotation: "Education is what survives when what has been learned has been forgotten." Skinner published that sentence the same month that I last addressed Convocation, May 1964. I acknowledge my huge debt to this, my alma mater, my bounteous mother. The university's law faculty here is the second or third oldest in common law Canada. It was founded by John Weir, the Vinerian Prize winner in Oxford. He became Dean of Law here after a recruitment competition among the pick of the legal scholars of North America. A master of Socratic teaching, he was the most electrifying law teacher I have ever heard of. One of my teachers here at the Faculty of Law was Dr. Alexander Smith. He got 2 degrees here and 2 from Stanford, including what was then a very rare graduate degree. I have never encountered a better university teacher than him in Oxford or anywhere. Dr. Smith created and gave each law class deep analysis unavailable elsewhere. But no law graduates are here this morning. we gather here to honor those of you getting your degrees today. I also honor those who taught you. Of all professions, teaching is the greatest. It does far more than protect or repair. A scholar's discoveries enrich the world. But a scholar's teaching improves the human race. Successful societies' enduring economic and ethical assets are not factories nor bank accounts. Its assets are technical, commercial, and ethical traditions. 20th century history proves that. Churchill said, "The empires of the future are the empires of the mind." So those riches and standards would erode without educated people to enforce and implement them. And if we lost those riches, in a generation or two, our educated people would rediscover most of them. Therefore, the true wealth of society is its learning and its willingness to implement it. Where is the latest addition to those riches? In the front rows here. You, our new graduates. Let's examine you. How did you become so accomplished? Partly by all your efforts and those of your families, and Alberta taxpayers' contributions. But mostly from the people who taught you. The idea that society owes much to its teachers is not novel, especially on days when diplomas are handed out. Each of you new graduates, ask yourself a question. Ask yourself this: how grateful to my teachers am I? Not enough. That sounds harsh. I accuse you of ingratitude, though I've never even met you. Why? Because you cannot be grateful enough unless you can calculate your debt. Cruel irony shortchanges all good teachers. No outsider can really properly assess good teaching. Universities do not teach publicly. Only the students attend lectures. And the needs and susceptibility of each student differ. Various students differ in who they learn more from. And most teaching's active. So your own role in learning further cloaks your teacher's contributions. You did not learn in isolation. You and your fellow students debated, explained, elicited ethical and emotional responses, and so motivated each other. Stephen Leacock said universities should build coffee rooms before libraries or lecture halls. But who stirred your classmates to those efforts? Your teachers. Both Plutarch and Wilder Penfield said that a student mind is a fire to be lit. You felt its flames, but you don't recall the match. Most important, learning erases your memory. No one, given good teaching, has the physical ability to recognize the size of that gift. Why? Because an effective teacher reshapes your brain. How does each of you differ from the person that you were in grade 12? No one really knows. Certainly not you. Your mind formed new connections and now views and analyzes your universe differently. You have lost your former ways of seeing or thinking about things. Gone are many of your brain's old circuits. Your mind is now more integrated and works faster. It is not an attic storing information, but a set of working circuits. At first, you could not master your large adolescent brain. Now, your brain is adaptable and complex, so much so that it has no good analogy. It's a bit like a sophisticated, high-speed, self-revising computer. Think again about that person with your name back in grade 12. You might recognize his or her face, but if you met your old self, you would not like or recognize your old thinking. Believe in your heart that you owe a moral debt to your teachers, though you cannot assess it, see it, or feel it. Your biggest debt may be to the instructors you liked best, but it may not be. It may not be to the instructors you liked best. It may not be to the instructors who amused or flattered you. It may not even be to the professors you disliked the most. The teachers who excited you deserve thanks, but they may not have reshaped you the most. Probably your biggest debt you owe to a few instructors. Maybe they had no particular style, no ego, no fame. Maybe some were young, closer to your cautious basic learning stage. They sent out a reading list, then walked modestly into the lecture room. They made the topic straightforward, though sometimes you struggled to keep up. Their courses ran efficiently, quietly, bit by bit. They helped you rewire your brain. Now you cannot really say who they were. They may never get awards, never make great discoveries, never publish famous papers, never get big grants or promotions. Like the unknown soldier, they carry on steadily to the end. Yet they remade you. Anything you achieve in the future, you will achieve with what they made, a new you. Now, you have an education and a degree, both from a great university of the highest standards. Always remember, tucked away in this university are a few teachers who transformed you. Honor your alma mater. Thank you.
Good morning. My name is Ubaka, and I'm an assistant professor in this faculty. I'm the moderator for the first panel on Justice Cote's contributions to tort law. I am honored to introduce two very distinguished colleagues and speakers on this panel, the Honourable Roseman, Justice of the Supreme Court of Canada, and Professor Annalise, a colleague here in the Faculty of Law. I've been asked to keep my introductions brief because we're running out of time. We're running behind on time. A request that I accepted only because I think most, if not all in the room, already know these two brilliant legal minds. Our first speaker is Justice Brown. Justice Brown was appointed to the Supreme Court of Canada on August 31st, 2015. At the time of his appointment, he was serving on the Courts of Appeal of Alberta, the Northwest Territories, and Nunavut. Prior to his initial appointment to the bench, he was a professor of law at this faculty for 9 years, as well as associate counsel at Miller Thompson LLP. His appointment to the bench is significant in many ways, and personally for me, as he abandoned his torts class to me in the middle of the term, it was ensured that I'll forever be compared to one of the best instructors to grace these halls. Justice Brown will speak for about 20 minutes. Justice Brown.
Thank you, Professor Ogbogu. Chief Justice, Justices,
Chancellor Stollery, Dean Paton, members of faculty, students, members of the bar, Justice Cote, Mrs. Cote. As the Justice of the Court of Appeal of Alberta, Jean-Edouard Léon Côté shaped the law of Alberta and Canada for 28 years. Armed with an articulated knowledge of the common law and a deep understanding of its method and his considerable gifts as an expositor of the law to public, to council, and to other courts, Justice Cote amassed a significant body of case law. This is a legacy which continues to inform broad swaths of our law, including our laws of commerce, the Constitution, crime, contract, estates, family relations, judicial, natural resources, and property. And of course, as Professor Billingsley will discuss, today Justice Cote is, alongside Justice Bill Stevenson, the master of the civil procedure, without which very little of this legal development would matter, since, as Peter Burks once pithily explained, procedure delivers the law. Indeed, most of what might call Justice Cote's tort law judgments are really judgments in civil procedure, so I'm afraid the pressure to deliver this morning is really on Professor Billingsley. Justice Cote's remarkable record of service to the law and to the Canadian people, whose prosperity and freedoms it secures and protects, would not, I suspect, have surprised then Justice Minister Ray Natishan when he recommended Justice Cote's appointment to Cabinet in 1987. In the course of preparing that recommendation, he would have learned that, and from and including his time in law school, Justice Cote had been a prolific scholar and eager teacher of the law. For example, as a young lawyer 42 years ago, he wrote what I still regard as the leading scholarly examination of the reception of English law in Commonwealth nations. As an even more pertinent example, 50 years ago, and as an even younger lawyer, he wrote a comment in the Canadian Bar Review asking whether the new remoteness rule stated by the Privy Council in Wagon Mound No. 1, which contradicted the long-standing rule in Polemis that the defendant would be liable for all direct results of negligence, whether or not foreseeable, was the proper rule to be followed in Canada as a matter of stare decisis. The law in Canada, he pointed out then, was by no means clear, owing to the Supreme Court's failure to address the question squarely or clearly. Sooner or later, he predicted, the Supreme Court will be faced squarely with the problem, and an early chance to have the matter finally settled would be most welcome. And if by sooner or later Justice Cote meant 39 years later when the Supreme Court finally pronounced it Mustafa and Culligan, he was absolutely right. To be clear, my focus on one small aspect of Justice Cote's contribution to the law, his decisions on appeals concerning tort law, reflect the limits of my expertise, not his. It is, of course, true that courts of appeal in Canada hear very few torts appeals. While many thousands of personal injury claims are brought across the country each year, only a minute handful reach trial. Fewer still are appealed. Most go nowhere or are resolved by other means, including mediation, also an interest of Justice Cote's. This does not, however, detract from the importance of a stable body of judge-made law. Indeed, it shows its importance because the more consistent, principled, and predictable the law, the easier the claim is to resolve without going to law, or at least going to trial. Justice Cote knew this. His judgments brim with this very insight, and I believe that insight informs what I see as several themes which emerge from the judgments. First of all, and this was touched on by Chief Justice Fraser, a view that the law should be logical and appeal to common sense. And secondly, that while appellate courts should be mindful of the limits of their powers when it comes to reviewing trial judges' answers to questions of fact and exercises of discretion, they must see that settled law is applied, that stare decisis is maintained, and that justice is done according to law. Justice Cote once wrote of Justice Stevenson that in a very partisan age, Bill's thoughts, arguments, and writing were never shaped by partisan considerations, prejudgments, dogma, social theory, or politicized views. An important reason for that is his distrust of theory, which is unrelated to experience. As the laudatory tone and intent of that statement suggests, Justice Cote shared that mistrust. But he also exhibited mistrust towards theory that was unrelated to logic. For him, Holmes's aphorism, "The life of the law has not been logic, it has been experience," is partly wrong and partly right. The law was, of course, properly shaped by actual experience, otherwise it wouldn't work. But for the same reason that the law had to work, it had to be logical, in the sense that its reasoning and its effects had to be defensible according to rationality. More than once, Justice Cote described his task as an appellate reviewer as being to search for a discernible error in logic in the trial judge's reasons. The search for logical error extended to counsel's submissions. In Campbell Estate and Calgary Power Ltd., the defendant Calgary Power, which had been sued by the estate of an unfortunate pilot of a plane that struck an unmarked power line that Calgary Power had erected near a private airfield, lied inter alia upon non-binding guidelines published by the Ministry of Transport for building airfields. That policy commented upon the proximity of obstructions, suggesting that flightway approaches be free of obstructions that exceed 1 foot in height for each 20 feet in distance from the end of the basic graded area to a distance of 3,000 feet therefrom. Calgary Power's point was that it had met the guidelines since its power line was located further than 3,000 feet from the airfield. As Justice Cote observed, however, it does not follow, as a matter of logic, that a policy recommending where obstacles should not exist is also a guide for when to warn them. Continuing, he explained, a rule forbidding wild animals as pets in the city would not let one keep such a beast under a sign saying, beware of tiger. As avid court watchers in Alberta know, this was hardly the only instance in which Justice Cote put analogy to service in the cause of showing the logical fallacy of an argument. In one of his best-known later judgments, Peniche Estate and Toll, the plaintiff and later his estate sued the defendant physician for having negligently misdiagnosed his incurable stomach cancer as gastritis, thereby accelerating the end of his life. This case involved many issues. In fact, soon after the judgment was released, I added it to my syllabus for tort law and my syllabus for civil procedure, since it covered the scope of recoverable loss under the Fatal Accidents Act, the use of statistical evidence in satisfying causation and costs, all of which Justice Cote adjudicated, as you would expect, deftly and with an experienced hand. But it was the part of his judgment dealing with the mitigation argument raised by the defendant that caught my eye. After his chemotherapy was discontinued at Edmonton, the plaintiff had traveled to the United States for further therapy, and his estate sought recovery of the expenses. The trial judge had granted that recovery, but the defendant argued on appeal that those expenses were not incurred in true mitigation. Just as he had not caused the plaintiff's cancer, he had not prevented any possible cure, since the cancer was incurable by the time he'd been consulted. There was, therefore, nothing to mitigate. Although the plaintiff's argument was disposed of on the basis that it hadn't been raised at trial, Justice Cote nonetheless discussed the merits of the issue. The issue, he said, was not whether the therapies pursued in the United States were effective in mitigating the loss which the trial judge had found resulted from the defendant's negligence. Rather, it was whether pursuing those therapies were reasonable attempts to mitigate that loss. He then conceived of the law governing recovery for mitigation of damages in a manner which I've not seen done elsewhere, but which seems to be fundamentally sound and essentially reflective of what the cases say. He said, harm caused by a tort includes all the expense or detriment from natural or reasonable human reactions to that harm or threat. Now that seems to be undoubtedly true, but I'm unaware of it ever having been put in terms of natural human reactions to harm or threat. And yet, as I say, it seems to me indisputably sound, and it's reflected in the cases. As Justice Cote explained, it's striking how extremely slow, as he put it, courts are to criticize good faith decisions by victims about whether to take steps in mitigation or which steps or how much expense or risk to incur in doing so. One has to account, he seems to be saying, for the stakes to the claimant as the claimant would reasonably have seen them, which in this case would have been almost immeasurably high. This led to discerning the logic of the matter as Justice Cote saw it. The stakes were, as the defendant physician saw, a cure. And yes, the cancer from which the plaintiff suffered was terminal. But from the claimant's standpoint, a cure was not the only objective. So was slowing the inevitable progress of the cancer. The role of logic was not confined in Justice Cote's judgments to answering the trial judge's reasons or counsel's submission, but also to shaping the law itself. Although he didn't put it this way, I see his point as this. The law retains its rule on the strength of its credibility, and it retains its credibility if it remains rational. If the law is an ass, the law will not be the law for long. One of his judgments on matters of tort law particularly leap to mind in this respect. In Ed Miller's Sales and Rentals versus Caterpillar Tractor, the plaintiff Ed Miller dealt in parts for machines manufactured by the defendant Caterpillar. Sometimes the parts were manufactured by Caterpillar itself and sold to Ed Miller through authorized dealers, and sometimes the parts were manufactured by others. At the material time, Ed Miller bought heavily from an authorized dealer in Illinois called Peoria Tractor. Caterpillar then issued a policy directive to its authorized dealers in the United States, forbidding them from selling parts to anyone outside the U.S. who was not an end user of the parts. Peoria Tractor ultimately complied, thereby substantially reducing Ed Miller's supply. Ed Miller sued Caterpillar, alleging, among other things, Justice Cote described the lawsuit as elephantine, one of the economic torts, interference with contractual relations, specifically alleged that Caterpillar's policy directive interfered with Ed Miller's contract with Peoria Tractor, thereby depriving Ed Miller of the benefits of Peoria's performance thereon. And this claim succeeded at trial. In reversing the trial judge, and I might add in a judgment that shows his superior command of tort law and contract law, Justice Cote spotted a problem, being that Caterpillar did not initially interfere with the contract between Miller and Peoria. What happened was after Caterpillar had issued its policy directive, Ed Miller and Peoria had first ignored it and continued to do business as usual while telling Caterpillar that their contract ran to the end of that calendar year, which was a somewhat questionable representation given that the notice provisions under that contract were unclear and indeed had been put before the trial judge. In any event, it was only that Caterpillar relented and agreed that Peoria Tractor could continue to supply Ed Miller for that term. In other words, performance of any contract between Ed Miller and Peoria, of which Caterpillar had notice, had remained free from interference. For Justice Cote, that was fatal to the economic torts claim. The law, he said, must require that the defendant have known there was a contract and have known its relevant terms. He explained what he saw as the logic of the proposition. A defendant does not commit the tort if he does not interfere with the performance of a plaintiff's contract. It follows that if the Defendant's Act does not interfere with the performance of the contract, there is no tort. Even if there's a contract whose performance would be impeded by the Defendant's Act, that act is not enough to result in liability if the defendant didn't know of the contract. Such an outcome, he said, would be illogical, since it would be, again pressing analogy into service, a purchaser could not purchase a lot from a seller who had previously contracted to sell a different lot to a third party. And speaking of logic, this view of the matter, that knowledge of the contract is necessary to ground the tort, was, as he saw it, the only explanation for a long line of authorities in Canada and England that inquired into the plaintiff's willful blindness or recklessness, since logically were, as he said, the defendant's knowledge that the plaintiff has some contract or other to suffice, it would not be necessary to go on to speak of willful blindness or recklessness. Now, of course, the economic torts are a bit off the beaten path when it comes to modern Canadian tort. The tort of negligence has, over the intervening 90 years since Donahue and Stevenson, consumed much of our judicial attention in the law school tort law curriculum. And here too, Justice Cote's infusion of law with logic is evident. In Bowes and Edmonton, the plaintiff homeowners sued the city when sections of the North Saskatchewan riverbank adjoining their homes collapsed, destroying one home and leaving the rest unsalvageable. The allegation was that the city had negligently failed to warn the homeowners at the time of applying for building permits that riverbank stability was already a demonstrated problem in this particular neighborhood. One of the many reports said to demonstrate this problem was the 1977 Hardy report, prepared for the city in relation to the proposed extension of Whitemud Road, and which recommended that slopes be left in their natural condition in a particular area, which was the area that later collapsed and on which the plaintiffs had since built their homes. The resulting judgment is well known for its consideration of Alberta's then new ultimate limitation period. It's also important for its discussion of cause and fact and loss of a chance. But for me, the most interesting aspect is in Justice Cote's reasoning, is the part that led to the conclusion that the City of Edmonton had not breached the standard of care. Significantly for Justice Cote, the trial judge had not found that the plaintiff would not have built the city, or would not have built had the city made them aware of the Hardy report, but rather it was that had the city reconsidered that report, it would have commissioned more technical reports before deciding whether to let plaintiffs build. But even that more modest conclusion was highly unlikely, Justice Cote thought, given the evidence that more thorough studies would have cost the city between $100,000 and $150,000, which, as he pointed out, in those days would have approached the worth of a large home. He then added, in tort law, the goal is not perfection at any cost. Risk must be balanced against cost or disadvantages of the possible precaution. Precautions need not be taken which are more costly than the risk. It would not have been reasonable for the city to require, say, a $100,000 study to protect a $100,000 house, just on the ground that the sum was not coming out of the city's pocket. That would not have helped the plaintiffs. expense was a relevant and necessary factor for the city to weigh. Although Justice Cote had authority on his side, which he cited, he was tapping into and firmly taking sides on a long-standing debate about which he would undoubtedly have been aware, regarding what it means to be a reasonable person, as that person is understood for the purposes of assessing allegedly negligent conduct. In United States and Carroll Towing, Justice Learned Hand defined unreasonable conduct as the failure to take precautions that would generate greater benefits in avoiding accidents than precautions would cost. The greater benefits being the product of multiplying the probability of an accident by the likely loss that would result. On the facts of that case, where an unattended barge broke away from its moorings and collided with another ship, the question of whether a reasonably careful person would have left the barge unattended would therefore be determined by comparing the cost of attending the barge to the risk as determined by multiplying the likelihood of an accident and the monetized value of likely loss or injury. Were the financial burden on the defendant of attending the barge less than the probable cost arising from not attending the barge, the standard of reasonable care would be taken as having required the defendant to attend the barge. Were, however, that burden to exceed the probable outcome of not attending the barge, a reasonable person would not take that precaution. In McCarty and Pheasant Run, Justice Posner described this learned hand formula as having greater analytical than operational significance, since conceptual as well as practical difficulties in monetizing personal injuries may continue to frustrate efforts to measure expected accident costs with the precision that is possible, in principle at least, in measuring the other side of the equation, the cost of burden and precaution. But he did not doubt the formula's utility, and indeed he applied it in McCarty. One sees hints of this formula at work in the canonical English case of Bolton and Stone. There the plaintiff was struck and injured by a cricket ball that had been hit by a pitch into the adjacent lane that backed a row of houses. The probability of this occurring was extremely small. The evidence suggested it had occurred as infrequently as 6 times in 30 years. Did that infrequency matter? Lord Reed said that on its own it did. In the crowded conditions of modern life, even the most careful person, he wrote, cannot avoid creating some risks and accepting others. In this case, the risk was foreseeable. It had happened 6 times already, after all, but almost infinitesimally small. Was that enough to absolve the defendant? Not yet, cautioned Lord Reed. One also has to consider how serious the consequences are likely to be if a person is struck. On balance, however, in that case, the low probability of risk materializing into harm in this case weighed heavily, and the defendant was absolved of liability. So one side of the learned hand formula, probability of injury and potential magnitude of injury, were accounted for by Lord Reed. But what about the other side of the ledger? That is, what of the burden on the defendant of taking precautions by, for example, moving the cricket pitch into the countryside? And on this point, Lord Reed demurred. I do not think, he said, that it would be right to take into account the difficulty of remedial measures. If cricket cannot be played on a ground without creating a substantial risk, then it should not be played there at all. I wonder what Lord Denning would have thought of that. 15 years later, Lord Reed in Wagon Mound No. 2 glossed over Bolton and Stone as a case where the risk was so small that a reasonable person was justified in disregarding it. This is, to my mind, a fair reading of his speech in Bolton and Stone, or at least fairer than what he said next, which was that it had also been reasonable to disregard the risk in Bolton and Stone because of the considerable expense in eliminating it. Fair or not, this allowed him to distinguish Bolton and Stone from the facts of Wagon Mound No. 2, in which oil had been discharged into a harbor due to an improperly secured fitting that only needed to be tightened. So as a consequence, the learned hand formula could be considered in its entirety: probability of loss, magnitude of loss, and cost of precautions, because the probability of loss in that case was slight. Justice Cote's statement in Bose diverges from this because it is categorical. The cost of taking care must always factor into the analysis. And this is entirely consistent with his distrust of theory, since there being no logical basis for distinguishing between cases of high risk and cases of low risk in deciding whether to consider the cost of precautions. One would then, to support drawing that distinction, have to resort to some sort of normative standpoint that may or may not be widely shared. To my knowledge, this debate has not yet been joined on the Court of Appeal, and my present court has never considered the matter. But if and when it does, the challenge of Justice Cote to defend any such distinction on the basis of logic will have to be answered, conceded, or in true Supreme Court style, ignored or avoided. As I mentioned at the outset of my remarks, Justice Côté's tort law judgments reflect more than just a view that logic should govern outcomes and legal development. He also expressed through them the view that while appellate courts should defer to trial judges' answers to questions of fact and exercises of discretion, all deference is cast aside when it comes to questions of law. Settled law must be applied, and stare decisis must be maintained. As to the appellate posture towards trial judgments, Justice Côté's tort judgments reveal care not to overturn trial judges simply because his own view of the evidence conflicted with the decision below, or because he would have weighed the evidence differently. Even in cases where he ultimately overturned the trial decision, he was generally quite hesitant, for example, to reweigh expert evidence opinion, overturn findings of fact, or question the trial judge's exercise of discretion. Still, as we can see, for example, in his decision in Bose, Justice Côté did not spare trial judgment scrutiny to discern the logic of the matter as suggested by the evidence. Nor was he one to let trial judges simply ignore expert evidence based on technical knowledge, except where, as he said, the expert's thinking or the profession or trade's practice, properly understood, must offend, you guessed it, logic or common sense. Even on questions of fact, then, Justice Côté was no meek appellate reviewer, and less so when it came to development of the law. But even here, he knew the limits of his role. He did not consider himself free, as he described it in Campbell Estate, to debate airily what the law should be. If the weight of the common law was clearly against the arguments being made, he felt himself bound to apply it, as he did in Campbell Estate and as he did in Bose. Similarly, in Sun Life Assurance Company of Canada versus a numbered Alberta company, in which it was argued that it was unfair to bar indemnity against a co-tortfeasor on the basis that the plaintiff could not have brought the claim itself, Justice Côté acknowledged the unfairness, but explained that that was the product of two well-settled common law rules, and it was too late to change the results by judge-made law. He was not free to amend the Tortfeasors Act or overrule the Supreme Court of Canada or prior decisions of the Court of Appeal in order to remove express limits on contribution. There is an uncommon degree of judicial humility in such decisions. Justice Côté had the deep legal knowledge and powerful writing to take up the mantle of hero judge, but he resisted this. Indeed, he regularly disclaimed it in the pronouncements that I've described. This is not to say that he did not see present needs as having to spawn further legal development. Courts exist to develop the law as well as to discern it and state it, and he knew that. But he was also mindful that in doing so, we judges are servants of our Constitution, with its separation of powers and the limits that it imposes upon judicial power. He also knew that judges come with the full gamut of human frailties, including the capacity to be terribly wrong while having convinced ourselves that we are infallibly right. There is value, both intrinsic and precious, he knew, to recognizing one's limits, both personal and constitutional, to recognizing stare decisis and the commercial and social stability that it engenders and preserves. And a reference to judicial humility is probably an apt segue to some concluding remarks about Justice Côté. Most of us are likely to have too little humility than too much. This is especially true of judges, of course, because inside and outside the court, we're used to people deferring to us. We're accustomed to people ceasing speech when we speak. We're used to people laughing at our jokes, or prefacing our answers to even our dumbest questions with a phrase, "That's an excellent question." See, you're laughing. It is easy, given our human frailties and our vanities, to be seduced by all this, to actually believe what people say about us and about what we say, to become proud. Justice Côté's torts case law, however, presents an example of the important advantage that judges in the common law tradition have, should they choose to employ it, in order to avoid problems that come with judicial pride, and that is that our role is not sufficiently discharged by merely pronouncing judgments from some Delphic throne on high. We must demonstrate by reasons why the solution we arrive at fits within the legal order. Our legal tradition is reasoned. It is not merely a system of rules. It has to make sense. It has to appeal to logic, which is why Justice Côté's concern for that quality was not some mere preference. It was the means for him and other judges to avoid indulging in the prideful claim that our own idiosyncratic view of the world is the view that should prevail. One final comment. As I read the judgments that I've recounted above and others, I was struck by the constant concern, an implicit and latent concern, for this was not a judge who tended to Cardozo-like ostentation. For doing justice according to law. Justice is, of course, served by logic and stability, but occasionally a broader notion of justice was at work in Justice Cote's Tort's case law, and I have in mind his remarkable collaboration with Justice Cairns in Duncan Estate and Badley. The issue was whether claims for loss of future earnings survived the death of the victim. Justice Cairns authored the lead judgment, holding that they do, and he gave some guidance on how to calculate such awards. The dissenting judge in that case would have held that the legislature had, in framing the Survival of Actions Act so as to eliminate the claim of a victim who died instantaneously for damages and loss of expectation of life, intended also to foreclose those claims. Further, he doubted whether there should be substantial damages for lost earning capacity when life expectancy is shortened. The elimination of what the dissenting judge called the evil of a windfall to the estate of a victim would be defeated by allowing claims for the loss of expectation of future income. Justice Cairns did not respond to the dissent. In concurring reasons, Justice Cote did. He debunked the notion that because Alberta, like most if not all other jurisdictions, had repealed the head of damage for loss of expectation of life, it had also repealed the present head of damage. The issue, he pointed out, is not limited to cases of instant death, but also to persons who are seriously injured by tortfeasors, linger for some time, and then die of their injuries. Nor, he added, was the issue whether damages for lost earning capacity should be allowed where substantial, even where life expectancy is shortened. In Andrews and Grandin Toy, the Supreme Court had made it plain that he stressed that there is such a head of damage. The fact that the plaintiff might die the day after judgment or that the claim might be substantial does not reduce his damages nor remove his beneficiary's right to inherit them. Concluding his powerful contribution to this majority effort with Justice Cairns, in which each of these great Alberta judges' intellects and passion for justice were on full display, Justice Cote said this: "Why should the tortfeasor escape scot-free if the plaintiff dies the day before judgment is pronounced? Worse still, why should the tortfeasor who has made death imminent escape scot-free if he manages to drag out the litigation long enough that he produces the very death in question before judgment? In my view, the issues here transcend social utility of inheritance. They involve justice." I was privileged to have counted Justice Cote as a colleague, even if only for a short time. He was and is a true and wise scholar of the law and one of the very finest jurists I have ever known. The tort law of Justice Cote is unavoidably, given the limits of our appellate docket, not the product of much of his judgment-writing time, but it is obviously the product of a depth of judicial and scholarly attention that by its quality commands the judicial and scholarly attention of others. And in its emphasis on logic and on the limits of the appellate role and the importance of stability and stare decisis, it represents, I think, a microcosm of the judicial method of a great common law judge who knew and did his duty. I've been honored to reflect on it in today's proceedings, and I thank you for your attention.
Thank you, Justice Brown. Our next speaker is Professor Annalise Acorn. Professor Acorn teaches private international law, professional responsibility, and jurisprudence at his law school. And what amounts to personal connection to today's event, Professor Acorn article at what was then the firm Reynolds, Mirth, and Cote. Professor Acorn will speak for about 10 minutes. So Acorn.
Thank you very much, Professor Ogbogu. I am, of course, doubly honored in having the opportunity to reflect on Mr. Justice Cote's legacy and also to respond to these rich and insightful observations that Justice Brown has just given us. And I want to begin actually also with a really heartfelt thank you to Mr. Justice Brown. His infectious enthusiasm for honoring his former colleague has been just buoyed up the organization of this event at every stage of the way. So I really deeply thank you for that, Justice Brown. One of the hallmarks of Mr. Justice Cote's style is true human-to-human communication. With Justice Cote, one is always aware that one is being addressed as a fellow thinker. He never fails to communicate a genuine invitation to intellectual connection. The sources of this immediacy in his writings are many. One source is simply his character. He just is a legal live wire. Another source of this vitality, as Justice Brown has so ably pointed out, is Justice Cote's facility with fresh metaphor and apt analogy. Of course, Beware of Tiger is one of the best of these, but I can tell you that I know more than a few crowns who take both joy and solace in being able to quote Mr. Justice Cote in R and Diaz that the defense cannot demand that the Crown disclose a full list of all its unicorns. Now that's another judgment that was written by the court, but nobody is in any doubt about it. It was delivered by the court, but everybody knows it's a Picasso. In Justice Cote's work, there is no obfuscation, no empty calories, no intellectual ostentation, no baloney. As Ralph Waldo Emerson said of Michel de Montaigne's essays, cut these words and they would bleed. They are vascular and alive. It's a similar genius, I think, in Mr. Justice Cote that likewise animates the law. And elaborating further on how this is so, I'd like to take a bit of a closer look at three key elements that Justice Brown has highlighted, that is logic, experience, and justice according to law. And I'd like to focus in a little bit more on this elephantine case at Miller Sales and Rentals and Caterpillar Tractor. And here I think it's an opportunity to illuminate a little further the ways in which Justice Cote is an exemplar of Albert Einstein's adage, make everything as simple as possible and no simpler. So, let me begin as Justice Brown has with logic. Now, a spoiler alert is often required before the first sentence of one of Justice Cote's judgments. Now, of course, some judicial opening lines will kind of give a clue as to which side the judge is empathically allied with. For example, in Summertime Cricket is the Delight of All. Somebody remember who wrote that? That's not what Justice Cote does. No, he gives us in one crisp sentence the logical flaw in the losing party's position. So the opening sentence of Ad Miller Sales and Rentals is, the issue here is interference with performance of a contract by one who does not know that his act will interfere. We know how this is going to end already. Let's take a look a little bit at experience, how experience operates in this case. As Justice Brown has explained, the plaintiff Miller argued that the defendant Caterpillar had committed the tort of interference with contractual relations between Peoria Tractor and Miller to supply parts. So Miller was trying to set themselves up as an unauthorized dealer in parts. So the first hurdle that, of course, they needed to jump was to show that there was indeed a contract between Ed Miller Sales and Peoria Tractor. And the argument that Peoria was making was that there was no consideration. Justice Cote disposes of this very deftly, simply saying, any suggestion that Peoria got nothing from the arrangement would startle business people. Peoria got a large, valuable customer who ordered a lot and always paid on time. End of quote. So the contract between Miller and Peoria was made out, and in his finding of consideration, Justice Cote's resolute insistence that the law must not be an ass in the eyes of experience is clearly in evidence. Next, consider justice according to law. We've seen already that the ratio is that the defendant can't be held liable for a contract that they don't know existed. But again, how was it that the defendant didn't know? Why didn't the defendant know that the contract was there? And as Justice Brown has also pointed out, the reason they didn't know was because the plaintiff had told them that the contract was coming to an end. So the plaintiff was directly responsible for the defendant's lack of knowledge of the existence of the contract. So does that make a difference? Does the plaintiff's deception make a difference? And the answer that Justice Cote gives is, well, it might have had the defendant pleaded estoppel. So Cote writes, had Caterpillar pleaded estoppel, other evidence might have been led, and a new trial for that is unthinkable in this elephantine lawsuit. In any event, much the same result flows from the law of tort, end quote. So here we have a procedural glitch that is delivering that opportunity to elaborate the law. From there, from there on, and Cote's in his reasoning, plaintiffs having misinformed the defendant loses all salience in the reasoning. Pared down to its logical basics, it's only the defendant's lack of knowledge that matters. Let me point out one more interesting turn in the judgment. Again, after January the 1st, 1983, it's clear that Caterpillar really did act with the intention of putting Miller out of business. They were trying to do, the defendant was trying to do the plaintiff in. So in all fairness, can't the plaintiff complain about that? They're trying to put them out of business. And again, Justice Cote puts the point with maximum logical precision. He writes, it's not necessary to decide here whether logic without intent would suffice, but one must decide whether intent without knowledge would suffice. Now, remarkably, from here, and much to my delight, because I'm very interested in law and the emotions, Justice Cote goes into a discussion of the emotion of hatred. He writes this, in some torts or causes of action, hate or intent to cause harm or suffering may be part of the cause of action, but this is not one of them. Indeed, some of the classic cases say that dislike of the plaintiff or intent to cause suffering or harm to it is neither necessary nor sufficient to give a cause of action. Now, I don't know whether Justice Cote was reading Aristotle's rhetoric at the time that he was writing his judgment, but Aristotle's analysis of hatred in the rhetoric dovetails perfectly into the way that Justice Cote talks about hatred. Because for Aristotle, hatred, as distinct from anger, is the emotion that is driven by the desire for the non-existence of the other. Not to inflict harm, but the desire for the non-existence. And so hatred then, unlike anger, can be a very sort of bloodless, impersonal kind of an emotion. And of course, in many circumstances, acting on the desire to bring about the non-existence of the other is a hate crime. But not in the context of the competitive free market. So, Cote writes, what if hating a competitor and wishing that it were out of business were an alternate to any of the orthodox elements of a cause of action? Then many businesses carrying on perfectly fair competition would be guilty of economic torts to their competitors all the time. Okay? So acting on the desire for the non-existence of the other is not nice, but as Cote points out, in the competitive market, it is not contrary to law. That distraction disposed of, Cote lands the last logical jump on a dime, once again employing vivid analogy. He writes, it's impossible to have intent without knowledge. One cannot intend to affect a non-existent person or object any more than an only child can love his or her brother. What I find admirable about Mr. Justice Cote's reasoning here is not merely that it is without reliance on policy or dogma. It's also without any unnecessary recourse to finding a fault. The logical leanness of his reasoning facilitates not just an economy of language, but an economy of blame. Through his detached elaboration of the law, he reveals that in law, nothing turns on the defendant's hatred of the plaintiff, or indeed on the plaintiff's deception of the defendant. I want to conclude at this point by returning to Mr. Justice Brown's observation that Justice Cote distrusts theory divorced from logic or experience. And here, I want to confess that there is something vaguely troubling to me, I get ever so slightly touchy, about the way that Justice Cote uses the word academic. When in Campbell Estate in Calgary Power, he considers the possibility of a mirror on the wall that can choose between the fairest of academic utopias. When in Samson Cree Nation, he refers to an argument as academically interesting and at times even philosophical, I don't think he's being complimentary. So, why so negative about all things academic when, by all accounts, Mr. Justice Cote is almost as renowned for his writings, his academic writings, as for his writings from the bench? Well, let me offer a theory. I think that legal philosopher Joseph Raz gets it exactly right when he says that the task of the academic theorist is to perceive reality clearly, to give sensitive attention to experience, and from there to attempt to construct conceptual frameworks that illuminate that experience. I think that when Justice Cote uses the term academic with disapproval, he laments that too often we scholars fail in that task. We fall prey to the tendency to what John Henry Newman, in his book, The Idea of the University, termed reckless originality. We fail to perceive acutely, and we promote our conceptual frameworks with indifference to the ways that they obscure rather than illuminate reality and experience. We permit perception to be distorted so as to conform to our big idea. And this is the sense of academic that I believe Mr. Justice Cote rightly has no time for. In Justice Cote's Convocation speech that we just heard, he does great honor to the faculty of this university. Let us honor him in return by taking his skepticism about theory as an inspiration for our work as teachers and as scholars to strive to ensure that our theories are always faithfully married to both logic and experience. Thank you.
Okay, we barely have time for much else, but I'll exercise a moderator's privilege and ask a question of the two speakers. You both highlight in various ways Justice Cote's contributions to predictability in the common law and the deep and uncommon degree of judicial humility in his appellate decisions. However, in many areas of tort law, for example, government liability for historical wrongs, such as in the indigenous context, and medical negligence, predictability can create an insurmountable gulf between legal doctrine and justice. What would you say to the charge that stability and predictability of judgment, as captured by doctrinal stare decisis, can and does sometimes imperil creative thinking from the bench?
In the interest of time and also not wanting to get into trouble, I'll keep my answer fairly short on that. I mean, that's of course that's a subject that often crosses our minds. But I'll say this: if anything, I think actually stare decisis tends to, rather than stifle creativity, my experience, certainly the counsel that come before me and the decisions that we review, and in the decisions at our court, if anything, it tends to enhance creativity and creates an incentive for creativity. Of course, you always worry that these things can be taken, unquote, too far. I remember I had a trust professor, Donald Waters, a wonderful man who claims, and justly, some credit for the development of the remedial constructive trust. But he quickly saw creative counsel taking it too far, and I would sort of quip that in a public setting that we never want to see a maxim of equity that says the remedial constructive trust is the last refuge of a scoundrel. So the tension is in balancing creativity, not sort of upsetting stability. It's, I'm dodging the question, Professor Ogbogu, because it is a present concern. I don't have an easy answer to it, but we have to balance the judge. That's one of the great struggles of judging, is balancing the individual justice of the case. There's one struggle, balancing the individual justice of the case, but not upsetting apple carts. And one might always criticize individual judgments for what side of the line the judge came down on. But I think we need to at least be aware that that is the tension. We should make it explicit, and we should be clear and transparent as to why we come down on one side of the apple cart. That's as much as you're getting from me, in the interest of time.
Just one more dodge of that question. It just reminded me of a wonderful statement by a composer, I think it's Rachmaninoff, I'm not sure, who said that creativity is always fostered better by constraint than by freedom.
Good morning. My name is Vivian Stevenson. I'm honored to be moderating a panel to highlight the contributions of Justice Cote to the law of civil procedure. I suspect I'm here just to add Stevenson to Cote. If my father could have been here this morning, I know he would have liked to have been. I'm very, very pleased to introduce to you Professor Barbara Billingsley, who will commence the panel. Professor Billingsley completed her Bachelor of Arts and Bachelor of Laws at the U of A and was called to the Alberta Bar in 1991. She is a civil litigation practitioner, primarily in the areas of defense and defense. She continued her Master of Laws in 1995. She has been a faculty member at the U of A since 2001. Her teaching and research interests are in the areas of insurance law, civil litigation, and constitutional law in the context of civil justice. She is the author and co-editor of several texts, has published a number of articles, case comments, and book reviews, and her works have been cited in judicial opinions in courts across the country, including the Supreme Court of Canada. Her qualities as a teacher have been recognized. She has been awarded the U of A's Rutherford Award for undergraduate teaching and the Teddy Miller Teaching Award for the faculty of law. So without further ado, and in the interest of keeping this short, I will pass the podium over to Professor Billingsley.
Good morning. When I was initially asked to give this presentation, my intention was to identify a handful of judgments that would best illustrate for you the significance and enduring nature of Justice Cote's contribution to the law of civil procedure in Alberta. I don't know what I was thinking. That task is the exact opposite of looking for a needle in a haystack. As noted by Justice Brown, Justice Cote is renowned for his expertise on civil litigation process and for his writings on the subject. The difficulty with commenting on Justice Cote's contributions to civil procedure is not a lack of material to draw from. The problem lies in deciding which of the many worthy judgments to highlight as representative of his work in the area. So, cognizant of time restraints for this symposium, I've decided to make things a little bit easier on myself by taking a little bit of a different route. Instead of attempting to convince you that I have somehow divined the most significant of Justice Cote's many civil procedure rulings, I'm going to offer instead a temporal sampling of those judgments. Justice Cote's 28 years as a member of the Alberta Court of Appeals spanned 4 decades, running from the 1980s to the 2010s. So, To illustrate Justice Cote's contributions to the law of civil procedure, I'm going to focus on 4 cases, drawing one from each of those 4 decades. The cases I've chosen all have several features in common. First, they're all decisions in which Justice Cote wrote the reasons for a unanimous Court of Appeal. Second, they have all been and continue to be frequently cited by Alberta courts. I did a quick law search, and up to the end of 2018, the 4 cases that I've chosen have been referenced by Alberta courts a combined total of 249 times, including 49 times in the past 2 years alone, with each of the cases having been cited more than once in that last time period. They are, of course, cited in other jurisdictions as well. While the significance of case law is not demonstrated by the numbers or citation rates alone, I think these numbers offer a rudimentary measure of the enduring legacy of Justice Cote's contributions to the law of civil procedure in this province. The continued citation of these cases in recent years is particularly notable because 3 of the 4 judgments were issued on the basis of Alberta's former rules of court. As many of you know, Alberta implemented a fully revised rules of court in 2010, and yet Justice Cote's preceding judgments remain relevant. Finally, and most importantly, each of these decisions reflect 3 overlapping themes which I think are inherent in all of Justice Cote's civil procedure judgments. The themes I'm referring to were already alluded to by Chief Justice Fraser and Justice Brown, but to reiterate a couple of them. First, that civil litigation, and therefore civil procedure, is a critical aspect of our legal system. It's designed to provide a fair and just method of resolving disputes among private parties. Second, that civil procedure works in the service of the substantive law and should be applied as such. And third, that the rules of civil procedure must be applied in a principled manner, reflective of the rule of law, not only to remedy the conflict between the parties in a given case, but to advance and contribute to the overall purpose and operation of the civil justice system. In the cases that I have selected, these themes are drawn from Justice Cote's purposes and practical analysis of the procedural rules in dispute. His down-to-earth, no-nonsense approach is a dominant, if not the dominant, feature of Justice Cote's civil procedure judgments. In the context of civil procedure, it's a methodology which ensures that the rules of court are applied in a meaningful and predictable way, consistent with the purpose and function of civil procedure as a whole. To borrow Justice Cote's own words, this approach avoids sterile abstracting or abstract theorizing about procedural issues. In my view, it keeps civil procedure civilized. With these ideas in mind, I'll turn to a review of the 4 cases. The first case I have selected is called Crothers and Simpson Sears Ltd, and it's a case from the 1980s. In this case, an out-of-province plaintiff appealed a Court of Queen's Bench order requiring him to post $1,300 in security for costs. The appellate argued that Alberta's security for cost rule unjustifiably violated the Charter of Rights and Freedoms by unduly infringing upon a litigant's equality and mobility rights. The court rejected the argument and dismissed the appeal. The judgment in Crothers, written by Justice Cote, was issued on May 10, 1988, when Justice Cote was still new to his judicial role, having been appointed to the Court of Appeal in 1987. It was also a time when the Canadian Charter of Rights and Freedoms, and particularly the equality section in Section 15 of the Charter, was in its infancy as part of Canada's written constitution. Looking at the Crothers case today, Justice Cote's judgment is indicative of the thorough and incisive approach to civil procedure issues that marks his judicial career. It is also remarkably prescient of the future development of charter law in Canada. Justice Cote began his judgment by discussing how security for cost works. He noted that most of civil procedure balances the interests of both parties, plaintiff and defendant, and that the security for costs rule achieves this balance by giving the court broad discretion to grant or refuse the application and to set parameters for the value, manner, and time for the posting of security. He explained that the rule calls upon the court to consider relevant practical factors, such as the merits of each party's case, the financial means of the plaintiff, and how much time is allowed for posting security, and the consequences imposed by a failure to post security. In the context of the Crothers case, Justice Cote's stated reason for providing this detailed explanation of the security for cost rule was to provide a factual underpinning for the constitutional analysis. In a broader sense, however, this explanation stands alone as a leading authority on the purpose and operation of the security for costs rule. As for the charter arguments, Justice Cote concluded that the security for costs rule did not offend the charter's equality or mobility rights. At the time, the Supreme Court had not yet ruled on the proper test for assessing equality rights under the charter. Nonetheless, anticipating future Supreme Court findings, Justice Cote cut to the heart of the matter, holding that however equality is defined, and I'm quoting here, the maximum extent of forbidden discrimination must involve a less favorable legal position because of some insufficient criteria. Applying that test, Justice Cote held that the security for cost rule does not treat non-residents less favorably than residents because non-residence is not the sole determining factor for the awarding of security. Along similar lines, Justice Cote held that the security for cost rule does not run afoul of the Charter's mobility guarantee because the rule does not govern where one may live or work. It's about when one should make assets available to sue. Finally, Justice Cote held that even if the alleged charter rights were violated, the security for cost rule was justified as a reasonable limit under Section 1 of the Charter. In his Section 1 analysis, Justice Cote emphasized the importance of civil litigation processes in Canadian society in the following words. A fair system of justice to settle private disputes among subjects has been a prime public objective of civilized societies whose traditions Canada follows. The second case I want to talk about comes from the 1990s. It's called Dorchat and Krupka. This decision concerns the proper description of documents in what was then called an affidavit of documents, what is now known as an affidavit of records. The appellates had each provided affidavits describing the producible and privileged documents only by number. For example, documents mechanically numbered 1 to 20. The respondent applied for a further and better affidavit, providing the nature, date, author, and name of recipient of each of the documents. Noting that existing authorities conflicted on the point, Justice Cote set out to clarify the law regarding the proper description of documents set out in an affidavit of records. His judgment on this issue epitomizes his judicial pattern of grounding a practical solution in a contextual analysis of the purpose and intention of litigation procedure. He began by considering the purpose of pretrial documentary disclosure, explaining that the discovery of documents is a valuable mechanism invented in Chancery to prevent destruction or suppression of evidence, get admissions for trial, prevent surprise, and prevent fabrication of written or oral evidence. He then went on to translate that objective into practical terms. He said, an affidavit of documents must show unambiguously what documents existence it does or does not disclose. It must remove any uncertainty on the following vital question. If a piece of paper turns up later, or is tendered on a motion or a trial, has it been disclosed in the affidavit of documents? On this basis, he concluded that for both privileged and producible documents, the law requires only that each document be described in a way which makes it unmistakably identifiable. The indelible numbering of each document is sufficient to satisfy that requirement. In regards to producible documents in particular, Justice Cote postulated that any further detail in the description of documents is a matter of mechanics, convenience, and common sense, not a matter of law. In other words, the appropriate level of detail used to describe the documents depends on pragmatic factors such as the number of the documents and the complexity of the lawsuit. Justice Cote cautioned, however, that the description of producible documents should always be guided by the underlying purpose of simplifying rather than making litigation more complex. Here again, Justice Cote's propensity for balancing the interests of litigants with reference to the purpose of litigation procedures was evident. He stated that documentary disclosure should not be treated as busy work or a matter of form, but neither should it require pointless work or unnecessarily cumbersome methods. As vividly explained by Justice Cote, and we've heard already about his vivid explanations, we should be streamlining litigation, not burdening it with mystic incantations and ceremonies. Justice Cote's judgment in this case also revealed him to be a champion of the principle of privilege, once again prescient of more recent Supreme Court of Canada rulings which have reinforced the fundamental importance of privilege in the civil justice system. Noting that privilege is a matter of substantive law and that substantive law drives procedural law and not vice versa, Justice Cote concluded that any system of listing or describing privileged documents which gives away privileged information is unthinkable. After thoroughly reviewing existing authorities, Justice Cote rejected the suggestion that the description of privileged documents must include dates, contents, or the parties to the documents. He held instead that beyond identifying them by a number, the issue of how these documents are most usefully described without disclosing privileged information is ultimately a question of practicality. Since the passage of Alberta's revised rules of court in 2010, the Alberta Court of Appeal has revisited the requirements for describing privileged documents to specify additional disclosure requirements. However, in doing so, the court was mindful of Justice Cote's comments about the importance of protecting privileged information, and as expressly stated by the court, much of what was said in Dorchak still has resonance. The third case I want to talk about comes from the early 2000s. It's called Baum and 351-2061 Canada LTD. As recently characterized by Justice Topolnitsky of the Alberta Court of Queen's Bench, this decision is the leading Alberta authority on the amendment of pleadings. In the case, two original defendants appealed a court order permitting the plaintiff to amend its statement of claim to add 3 new defendants after pleadings had closed. The essential argument of the appellants was that the plaintiff had insufficient evidence to support the amended claims. Characteristically, Justice Cote addressed this argument by considering the court's authority to grant an amendment given the purpose of pleadings and the standards imposed by related procedural rules. He noted that the avoidance of multiplicity by encouraging joinder of claims is fundamental to our civil procedure, and that the rules for pleading in the initial instance require no evidence at all. He concluded that these factors militate in favor of permitting amendments prior to the expiration of a limitation period, even if the amendments include new causes of action. Further, he noted that an amendment may be allowed even if it includes a doubtful plea. He found that where the doubtful amended plea overlaps with clearly arguable claims, disallowing the amendment produces a real risk of injustice, but no real advantage. Accordingly, Justice Cote held that an application to amend does not need to meet the evidentiary standard of a summary judgment application. Instead, for the sake of consistency and practicality, the appropriate test should be very similar to that for striking out pleadings, or for service ex juris, where the plaintiff only needs to demonstrate a reasonable basis for the claim. As summarized by Justice Cote, all of these analogies confirm that a modest degree of evidence justifies an amendment to pleadings within the limitation period. And the analogies show that requiring a stiffer test to amend would be pointless, producing little or no practical result. To require a stiffer standard for evidence to amend would produce a motion for summary judgment in favor of the defendant without requiring the defendant to swear to anything. That is contrary to all principle. This passage that I've just quoted demonstrates Justice Cote's holistic approach to civil procedure issues and his insistence on developing the law of civil procedure as a consistent and integrated and principled whole. The last case I want to talk about, my fourth case, is Paniccia and Toll, already mentioned by Justice Brown. This case was decided in 2012, so it's representative of the 2010s section of Justice Cote's career. The case raised 2 civil procedure issues. The first was whether the trial judge properly refused to consider 2 arguments which were not in the defendant's pleadings and which were raised by the defendant for the first time in its final argument after the close of evidence at trial. The second issue was whether the trial judge was justified in awarding the plaintiff double costs on a full indemnity basis. Justice Cote resolved these issues in favor of the plaintiff, characteristically referencing the purpose, context, and practical operation of the relevant procedural rules. In holding that the trial judge properly refused to consider arguments that had not been pled by the defendants, Justice Cote drew upon fundamental principles of civil litigation procedure. He recognized as a simple application of the first rule of natural justice that each party have notice of the opposing party's case and a fair chance to encounter it. He further acknowledged that pleadings do matter for the purpose of providing that notice, and that a judgment based on an issue not pleaded is improper. Finally, once again demanding logical integration of procedural rules, Justice Cote noted that if the defendant had attempted to amend its defense pleading to add the new issues, the usual principles of amendment would apply, including the elementary principle that pleadings cannot be amended late if the amendment would cause the opposing party prejudice and not be compensable in costs. He held that a defendant should not be permitted to sidestep these considerations by asking the court to consider the new arguments without applying to amend the pleadings. In regards to the issue of costs, Justice Cote focused on the judicial discretion afforded by Alberta's rules of procedure. He noted that, while in principle solicitor-client costs should not be commonly awarded, in Alberta and elsewhere, there is a very well-settled rule which gives a judge discretion to award larger than usual, even solicitor-client costs for significant misconduct during litigation. For the same reason, he rejected the defendant's argument that double costs cannot be awarded on the basis of a rejection of an informal as opposed to a formal offer. Justice Cote held that the fact that the rules expressly allow for double costs to be awarded in the context of a formal offer does not restrict the court's discretion to award such costs in the context of an informal offer. These findings on costs demonstrate Justice Cote's respect for interpreting the rules of court not only in a purposive context, but as they are written. This might seem like an obvious approach, but its importance to ensuring consistency and predictability in civil procedure law cannot be overstated. Obviously, the 4 cases I've reviewed are not a statistically significant sampling of Justice Cote's civil procedure decisions. They are a drop in the bucket. Nonetheless, I believe that they collectively represent Justice Cote's approach to civil procedure law during his time on the Alberta Court of Appeal. In addition to establishing or reinforcing principles about the particular rules at issue, these judgments provide a template for interpreting procedural rules. They demonstrate Justice Cote's commitment to the interpretation of civil procedure rules in a purposeful, consistent, logical, practical, and principled manner. About a year before Justice Cote retired from the court, the Supreme Court of Canada issued its seminal ruling in Orania and Malden. In this case, the Supreme Court of Canada called for a litigation culture shift, redirecting the focus of litigation from resolution by trial to resolution by the most fair and efficient judicial means possible. This new focus has been adopted in Alberta, and I think it makes Justice Cote's purposive and practical approach to the rules all the more necessary and instructive. Without the preparation or conduct of trial as the benchmark, it's critically important that the rules of court be interpreted and applied in accordance with a principled understanding of their purpose in facilitating judicial resolution. The foundational legal principles and the principles of consistency, logic, and practicality championed by Justice Cote are instructive in defining that purpose. Regardless of what changes are made to the Alberta rules in future, Justice Cote's rulings endure as lessons about how procedural law should be made. I'd like to end my comments on a personal note. In his 2017 Convocation address, which you had the opportunity to view this morning, Justice Cote spoke about the lasting impact of inspired or passionate teachers. For several years, I have aspired to be a passionate instructor of civil procedure, but Justice Cote sets the standard. I have never met anyone more passionate about civil procedure or about the enterprise of educating others about civil process. I consider myself fortunate to know him, and along with many others, to have benefited from his extraordinary knowledge of this important area of law. Thank you.
Thank
you, Professor Billingsley. I'd now like to introduce Justice Judy Ross. Apparently, Justice Ross was told to submit her biography via Twitter, so I will be very quick in terms of introducing her. Justice Ross practiced civil litigation in Edmonton from 1980 to 1988 when she joined the faculty of law at the University of Alberta. As an academic and a teacher, Justice Ross specialized in constitutional law and civil procedure. From 1991 to 2001, she was Associate Dean of the faculty, and from 2001 to 2003, she was seconded to the Alberta Law Reform Institute as lead counsel to the Alberta Rules of Court project. She managed to avoid having to continue in that role by being appointed to the Alberta Court of Queen's Bench in 2003. Some of us had to struggle longer with that project, as we saw here. Since that time, Justice Ross has written numerous decisions in the area of civil practice and procedure. In fact, when I called up her name and the category of civil practice and procedure, I got something like 90 judgments. So obviously, she has had ample opportunity to consider and apply Justice Cote's decisions in the area, and I and the rest of you look forward to hearing from her.
I note that the title of this program, this particular part of the program, is Keeping the Civil in Civil Procedure. Well, I will have no difficulty in doing that. I'm not going to reply in any kind of adversarial way. Having just recently gone supernumerary, heard a lot of cases, I feel that I have come to know a good case when I hear one. Sometimes Justice Cote has pointed out to me that, in fact, I have been led down the garden path. But nonetheless, in this particular case, I'm sure that Professor Billingsley's themes, the examples that she's used, are irrefutable, so I won't attempt to do that. Rather, as an addendum, I thought I would pick up on a theme introduced by Professor Billingsley about the litigation culture shift introduced by Hriniak and Malden, and the importance of Justice Cote's purposive and practical approach to procedural rules in light of the changing landscape. The redirection in dispute resolution from trial to other means recognizes the need for more efficient use of limited resources without sacrificing essential fairness. Now, a primary challenge, perhaps the primary challenge faced by the courts today is a shortage of court resources and the resulting delays in the administration of justice. The criminal law implications of this in Regina and Jordan and its progeny are well known. In family law, the need to use resources efficiently and to accommodate the increasing number of self-represented litigants has been, and no doubt will continue to be, the genesis of innovative procedures designed to encourage and facilitate early resolution of disputes. Now, in civil litigation, very much of what's going on happens outside the courthouse. So the impact of change is sometimes harder to detect or describe, but it is nonetheless certainly being felt. I'm going to mention two areas in which these forces are having a particular impact in the Alberta courts and in which Justice Cote's guidance will have a significant and ongoing influence. One relates to master's appeals and the question of the standard of review. In Alberta, traditionally, and as affirmed by Justice Cote under the 2010 revised rules of court, the standard of review of a master's decision on appeal to the Court of Queen's Bench is correctness. Rule 614 of the new rules, as we still call them, provides this, that an appeal from a master is an appeal on the record of proceedings before the master and may also be based on additional evidence that is, in the opinion of the judge hearing the appeal, relevant and material. Now, the standard of review under the new rule was considered by the Court of Appeal, by Justice Cote speaking for the court, in Bocelli and Yorkton Securities. That was a 2012 decision. Prior to that decision, there had been a number, there was getting to be a bit of a tide, I think, of Queen's Bench decisions, which had held that the standard of review under the new rule was deferential. Bocelli shares the characteristics of Justice Cote's procedural decisions discussed by Professor Billingsley. Oops, sorry. Okay, thanks. It is a decision in which Justice Cote wrote the reasons for a unanimous court. It has been cited by Alberta courts on numerous occasions. I did a Canalese search earlier this week, 195 citations of Bocelli and counting. And it reflects the themes of all of Justice Cote's civil procedure judgments. Justice Cote introduced the issue with his usual directness and clarity. The big issue in this judgment is the standard of review on appeal from a master to a judge. Terminology is not completely consistent for the standard of review, which was adopted before the new rules came into force. It is sometimes called non-deferential and sometimes called an appeal de novo, but more commonly the term used is correctness. Justice Cote then went on, organizing his reasons under two headings. First heading, do the rules set the standard of review? In other words, Justice Cote said, the place to start is the wording of the new rules. If they clearly address the standard of review on appeal to a judge, that would end the question. Justice Cote rejected the argument that had been accepted in Queen's Bench that reference to an appeal on the record determined the standard of review. As written, the phrase is about evidence, not the standard of review. And it is subject to a broad exception, allowing new evidence that is relevant and material. This makes a deferential standard impossible in many cases. At best, he concluded, the rules are silent. Which brings us to the next heading, what the standard of review should be. Or again, as helpfully elaborated by Justice Cote, that silence does not bar having a judge-made standard of review, it necessitates it. Justice Cote cited the consultation memorandum from the Alberta Law Reform Institute's Rules of Court project, which recommended no change to the standard of review, essentially on the ground, as put by the appellant in Bocelli, that nothing was broken that needed fixing. Justice Cote agreed that appeals from masters worked well, and he explained further. A motion to a master is not necessarily final. In theory, maybe counsel should have perfect foresight and assemble all the evidence which might possibly be relevant, couched in clear and unmistakable language. But no human being is perfect. And sometimes justice lies on the side of letting a party later patch up oversights and ambiguities in his or her first affidavit. Furthermore, requiring perfection the first time could well increase the net expense and delay in litigation. The cases in which an appeal de novo may seem to impose an undue strain on limited court resources are not typically the interlocutory matters dealt with by masters in morning chambers and rarely appealed to Queen's Bench. They are what is a current feature of masters' work today, summary judgment applications following the Lydia and Landon case, and they are also applications for dismissal for delay. So these are applications that can end a lawsuit. They are special applications. They often involve a very extensive record before the master. That record, of course, may be supplemented on appeal to remedy shortfalls, and indeed, the masters often helpfully point out shortfalls to be remedied. Scheduling these applications can take many, many months. In recent years, it's taken up to a year to schedule the application first before the master, and then up to a year again to schedule an appeal before a judge, and then, of course, one can, and really does, go on from there. However, as Justice Cote pointed out, if we look at those types of applications, the application where the action itself is at risk, the significance of the applications may actually support a less deferential review. And he pointed out that there are indeed jurisdictions in which that approach has been taken. Well, then we might say, should we have different standards of review for different cases? Justice Cote dealt with that as well. As to that possibility, he pointed to the difficulty that can be involved, and we all know about the difficulty from the area, of course, of administrative law, intransigence of dealing with that issue. So, Justice Cote observed in regard to this argument, having to determine different standards of review for different cases, quotes, would consume time and money and would be needless litigation about litigation. Now, as I say, by the time Justice Cote's discussion of these issues certainly reflected the consultation process during the Rules of Court project. By the time, however, that he heard the Bocelli case, he was making a decision that did go against somewhat of a pressure from the Court of Queen's Bench to decide otherwise. There are many who still disagree with this decision. There continue to be different views about it. Maybe there will be a legislative change at some time in the future. But I am reassured that in the meantime, we do have Justice Cote's judge-made standard. As I say, it's been cited in 195 decisions. It's a standard that does reflect, as Professor Billingsley described it, an interpretation of the rules of court, not only in a purposive context, but also as they are written. Justice Cote revealed both his practical and his principled understanding of civil procedure in concluding that the standard of review on appeal from a master to a judge on all issues is still correctness. The second issue I wish to mention relates to the dismissal of actions for delay, particularly Rule 4.33, known as the drop-dead rule. Of course, Justice Cote has written decisions about this rule, but I wanted to mention another contribution he made to civil procedure in his legislative role as chair of the Rules of Court Committee from 1990 to 2007. Justice Cote was chair of the Rules of Court Committee during the consultation and research stage of the Alberta Law Reform Institute's Rules of Court project. I was fortunate to act as lead counsel on the project in its early days, as noted, prior to my appointment to Queen's Bench. Justice Cote's support for the project was absolutely vital in getting it off the ground, and it was very much appreciated by myself and others were, of course, so lucky to have him continue in a very, very strong role on the project after I escaped, as Ms. Stevenson has suggested, to the Court of Queen's Bench. Now, the drop-dead rule is hard to get right. If it only requires that something that materially advances the action be done every 5 years, once every 5 years, that was Rule 244.1 of the former Rules of Court, it may be rightly seen as condoning undue delay. Accordingly, the new rule required that something be done to significantly advance the action in a 2-year period. However, with limited exceptions and no discretion in the court to extend time, some thought that the new rule would result in the unfair termination of meritorious lawsuits. The Rules of Court Committee, by this time under Justice Slatter's chairmanship, heard concerns about the new provision and undertook a consultation process. This was followed by amendments to Rule 4.33, increasing the period to 3 years and rewriting and clarifying the rule. But the underlying concern of the rule to deal firmly with delay was maintained. I believe I detect Justice Cote's continuing influence here. As he writes in the commentary to Rule 4.33 in the Alberta Civil Procedure Handbook 2019, delay in a suit is anathema to all principles in the 2010 rules: efficiency, proportionality, and economy. Like Professor Billingsley and Justice Cote, I've been a civil procedure instructor in my time. I too tried to be a passionate civil procedure instructor. I still found that there was a very limited number of rules that I could get through in a class before some people started actually reading newspapers on occasion. And this was back in the day when reading a newspaper meant unfolding a newspaper, not just looking at one's phone. So I will stop there with rules. I want to, however, also pay some brief homage to Justice Cote's love for metaphors. Justice Slatter provided me some research that a student of his did on the occasion of Justice Cote's 25th anniversary of the Court of Appeal, a memo entitled Colorful Phrases Used by Justice Cote. Justice Slatter described these as Coteisms, which I think is a lovely phrase for them. Like the Chief Justice, I was heartened to see the love of animals reflected in Justice Cote's frequent metaphors. I was particularly drawn to the horses, the escaping horses. I noted, as did the chief, that it's not just the old saw that we all know that we see in Justice Cote's decisions. As the facts get more egregious, so does the adage. So that the horse has not merely left the stable in one case, he was gone 5 months before the appeal was even filed. Or, the poor horse, his escape was illusory. He was out of the stable door, but already saddled by his new legal owner. I wanted to end with my favorite of the Coteisms that I have seen, and this comes from the same decision that the Chief Justice mentioned. This was a 2015 decision of the Northwest Territories Court of Appeal, Bell Mobility and Anderson. Bell claimed the contractual right to charge its customers in the Northwest Territories a 75-cent monthly charge for 911 calling, even though there is no 911 service in the Northwest Territories. Justice Cote for the court found that the contract, properly interpreted, did not provide for a fee for nothing in return. And just to make sure that the message was understood, he added, "In my respectful view, connecting someone to nothing is still nothing. A right to charge a door-to-door delivery fee for milk cannot be triggered by delivering empty bottles." Justice Cote always delivered the goods. Thank you very much, Justice Cote.
My panelists decided that they didn't want to dodge the question that was asked. They were just going to dodge all questions. So as we are at just past 11 and as a refreshment break is scheduled, I suggest we'll take our refreshment break and back over to the panel.
Good morning, everyone. We'd like to begin the next panel of the ask you to please take your seats. My name is Shannon O'Byrne. It is my honor to introduce the panelists who will be addressing the topic of the Court of Appeal and the changing nature of contract law. David Percy will present on this topic for 20 minutes or so, and then we will have the response from Chancellor Doug Stollery. I'd like to begin with introducing David Percy. He is our faculty's incoming interim dean. He is well prepared for that role, having been dean from 2002 to 2009. Professor Percy received his MA from Oxford, his LLM from the University of Virginia. You may know that Professor Percy's teaching and research interests are in energy law, water law, and contracts, with numerous publications to show for his decades of service at the University of Alberta. As another example of his contributions, I note that since 2000, David Percy has worked with the United Nations and Agriculture Organization on water law and agriculture in 6 African countries. One more quick word, Professor Percy has received major teaching awards at the national, university, and faculty level. In 2019, he was awarded the University Cup, the highest honor a U of A academic can receive for research, teaching, and service to the university and to his community. Please welcome Professor David Percy.
Thank you, Shannon. It's an honor to be able to deliver these thoughts about a person who I've known for a very long time. I first met Jean Cote within 4 weeks of my arrival in Duncan, where my colleague, Professor Bill Stevenson, as he then was, took us for lunch at the Old Bailey Steak Loft. For those of you who know, Bill paid. We have co-taught courses over the years. Whenever I co-taught with John Cote, I spent 4 times as much time preparing, just because I didn't want to be embarrassed by a real total lack of knowledge. And our lives have intersected frequently since. I'd like to begin by acknowledging 2 debts, 2 personal debts and 2 professional debts to Jean Cote. Those who know him well know he's an exceptionally kind friend and colleague. He showed these qualities to me at the very beginning of my teaching career. In the summer following my 2nd year of teaching, the law school had 2 nasty surprises. The first was that Dr. Alexander Smith, who taught contracts for many years, announced that he couldn't teach the following year because of ill health. The second surprise The graduating class of that year had consisted of about 100 students, and we discovered in August that our incoming class was 210 students in size. Rather than have me suffer through teaching a mega section in contracts while I was very much a junior teacher, Jean volunteered to teach a double section. So while a busy practitioner, he had 140 students in the contracts class. You might ask yourself, how did he get student engagement in a class that large? Well, I'd like to thank Judge Alan Fantrum for this clue on how it happened. Early on in the classes, Jean called upon a student to discuss a case, and the student said, I'm sorry, sir, I'm not prepared. John didn't say anything initially, he just opened his class record, took out his pen, put a visible X on the page, and then said, well, it's a very large class, I doubt whether you'll have a chance to redeem yourself. And after that, class participation was excellent. He performed a similar act of kindness just shortly afterwards. I just published my first article on contracts, which was a slightly unconventional account of the doctrine of frustration. And I was astonished one evening that Jean called me at home to say he very much enjoyed reading my article, and congratulations. By the way, I don't agree with all of his conclusions, but I did enjoy reading it. And when you were faced with bombing out with your first publication, that was a very comforting call to receive. At a professional level, he made two important contributions to my life. The first, Exhibit A, is his 1974 book, An Introduction to the Law of Contracts. That 1974 was the first book on contracts published in Canada since 1914. So it provided references to all these cases I read in other people's reading lists across the country, which had been decided over a 60-year period. So it was a wonderful resource to have. My pages are falling out. Wally Miss published it through Juraliber. He's responsible for the rather odd design of the book. I asked for my money back, and he said, I'll give it to you because we sold out completely and I don't even have a copy for myself. The second one was Jean's legendary participation in the bar admission course, where he taught a time management section. And that was the single most valuable thing I learned in my legal career. Because there are students in the audience, I'm going to tell you almost verbatim what I took from that class, because I remember it vividly. Number one, a lawyer has to be available to his or her clients, but not 24 hours a day. Two, there is no legal problem so large that it cannot be broken down into bite-sized components. That has to be your first job. Break the problem down. Three, identify your most productive time of the day and isolate a time period then where you will be free of interruptions for an hour and a half or 2 hours. There is no legal problem which you cannot make progress in 1.5 or 2 hours uninterrupted time. You then have the building blocks of how you're going to approach this difficult and complex case. Four, when you finish that period of isolation, you should then spend the rest of the day attending to all the messages received from your clients. And I have to say, I put that into practice whenever I'm trying to write something, explains to my colleagues why I'm very grumpy if I'm interrupted before 10 o'clock in the morning, and it's been invaluable advice. Now, my focus of my discussion of Jean and his legal contribution is going to deal with the changing concepts of private law that have occurred pretty much at the same time as Jean's judicial career. At the time of his appointment before, the field of private law in Canada is very tranquil. In this very room, at a conference celebrating the centenary of the Supreme Court of Canada, Dean Gerald Friedman was asked to talk about the Supreme Court of Canada and private law. He said, this remit is almost, though not quite, like giving dog a virtually meatless bone to chew. The net result is to whet the appetite without providing any substance. Or if you prefer it, salivation without salvation. And he's particularly reserved harsh criticism of the Supreme Court of Canada in the law of contracts. He commented that the court seemed unable to reevaluate the old doctrines of contract law and to provide insights into developments that occurred in English courts. He called provocatively for the Supreme Court to set the tone for lower courts by addressing emerging private law problems boldly and imaginatively. Well, about a decade later, the Supreme Court of Canada took up his invitation with a degree of enthusiasm. but not in the law of contracts. So I want to say that starting in the late 80s, the Supreme Court of Canada began to take very bold and different approaches to many areas of private law. The students in the class, and indeed Justice Brown has written about it, can tell you all about the developments in tort law. But there are two startling areas in particular. One was unjust enrichment, and the second was fiduciary duties. And in the unjust enrichment field, starting with a decision of Justice Dixon's in 1980, the court distilled the whole area of unjust enrichment into three elements. There must be an enrichment, a corresponding deprivation, and the absence of any juristic reason for the enrichment. This was a very odd and totally idiosyncratic distillation of the law. In fact, especially the no juristic reason one, really had no basis in the common law of the time. In 2004, in Garland and Consumers Gas, the court changed that basic principle a little bit in equally idiosyncratic terms. It invented a novel analysis of the Petkus and Becker test by saying that the plaintiff must establish that there was no juristic reason for the transfer. In other words, the plaintiff had to prove a negative by ruling out any possible reason for the absence of a juristic any possible juristic reason for the enrichment, which made it very difficult. And this was a very odd, unanimous reframing of the requirement of unjust enrichment into a declaration of a very broad principle that wasn't actually very closely linked to precedent. A similar thing happened with the law of fiduciary duties. In Freeman Smith, Madam Justice Wilson distilled the ingredients of a fiduciary relationship into three requirements. They focused on one, the exercise of discretion, two, the unilateral exercise of power so as to affect the interests of the beneficiary, and three, the vulnerability of the beneficiary. Although this was described as a rough and ready guide by Madam Justice Wilson and was in a dissenting judgment, it soon became a guiding framework for the courts. In fact, courts were preoccupied with elements of fiduciary duties for the next 20 years. It was a very unusual restatement of principle. What effect did it have? Well, serious according to other countries. I love the famous comment of Sir Anthony Mason, the Chief Justice of Australia, who said that in Canada there are three types of persons: those who have been held to be fiduciaries, those who are about to become fiduciaries, and judges. The one who is safe to say do not know fiduciary duties. Now, in her extrajudicial writing, Chief Justice McLaughlin described this style of reasoning as an example of universalism, the quest for broad general principles underlying the imposition of responsibility and the corresponding rights of recovery. Now, by definition, universalism is a top-down style of reasoning. The principle is stated, and then everybody, the law courts have to apply deductively what that principle means. In contrast to the traditionally inductive approach of common law reasoning. Now, contracts remained exempt from that area. The courts continue to follow the incremental change approach to contract doctrines, even in the area of privity. If there was one area of contract law that might have been susceptible to judicial reformulation, it was the privity principle. But the Supreme Court of Canada, in three major cases in the 90s, one after the other, altered some of the margins of the privity doctrine. London Drugs, Edgeworth Construction, Fraser River Pile and Dredge. But in each case, they laboriously said that we are making only small and incremental changes to the doctrine. We are not interfering with the doctrine as a whole. So I would suggest that Justice Cote was philosophically comfortable with this approach. And the Supreme Court of Canada remained, I think, very restrained in its approach to contract doctrine. In 2012, Justice Cote provided a trenchant summary of his views on this in the unanimous decision of Cote and Hillview Homes. The facts involved what could easily be a first-year examination in contracts on uncertainty of terms. The buyer alleged that it had entered a contract to purchase from a builder a standard new house, enticingly described as the Los Cabos II model, situated in the foothills outside of Calgary. But it was to be constructed in an area which had strict architectural guidelines. The buyer paid $1.2 million for the house and lot, but the trouble was the architectural guidelines said the minimum size of a house on that lot had to be 4,500 square feet, not 2,800 square feet. So the question is, how was it going to be big enough? Well, the terms of the contract said that the buyer could add 1,666 extra square feet from the standard design at a price of $80 per square foot. The problem was the contract offered no guidance as to where and how this big addition was going to be put onto the basic model. No idea whatsoever. So the purchaser had agreed to buy a house and a totally undefined addition. So, first-year contracts, the property was neither defined by the contract nor ascertainable by any criteria set out in the contract. So I think the decision of the court was uncontroversial, but it enabled Justice Cote to make two philosophical points. One, the overarching aim of contracts is to let two or more parties predictably govern themselves by their own self-imposed rules. Two, certainty and predictability are usually more important than fairness in any particular contract. And he grounded these philosophical concerns with practical reasons. He said, Canadian courts sometimes give the public and businesses certainty in contractual disputes, but too often they do not. Even a clearly written, signed formal contract leads often to 2 years of discoveries and days or weeks for trial. Each step explores the entire history of the contract negotiations, the subjective musings of each party, and every possible after-the-fact disappointment or windfall. Sometimes, he says, the second practical argument, courts go astray by encouraging parallel evidence, ignoring whole contracts clause, inventing collateral and written obligations, and implying far-reaching terms. They are reluctant to hold any agreement as too uncertain, to enforce and often do so by inventing terms which the parties never imagined, or leave the parties with a binding contract of unknown and unstated content. So, very strong objective interpretation. He follows this up in many construction law cases, most notably CNR and Volker Steven, where he points out that even if there's not an entire contract clause, you can't imply terms in a contract which contradict the express terms of the contract. Now, initially my colleague Professor Roseman drew my attention to the Bell mobility case, which has been the focus for what Annalise Acorn describes as some classic Jeanisms. I won't go back through the Jeanisms, but I will go back through the case because it is very interesting. As Drew pointed out, Bell Mobility charged its subscribers in the Northwest Territories a fee of 75 cents per month for 911 services, even though 911 was not available in the Northwest Territories. The way Justice Cote solved the problem was to say, well, the contracts never actually stated that the consumer had to pay for 911 service, as the relevant terms were all ambiguous and conditional. So, where wording of the contract is ambiguous, the court should be slow to adopt an interpretation which gives one party pay for nothing, or what is virtually nothing. Bell then tried to justify its right to payment by pointing out that if clients did phone 911 in the Northwest Territories, they were connected to a very useful recorded message suggesting we should recall local emergency services. But no telephone number for local emergency services. And so it was in that context that the turkey quotation, that a picture of a turkey is different from the delivery of a turkey, came out. I think it was very astute. But it does lead to what has become, I think, a brand new problem with standard form contracts in Canada. The classic cases, like Bell Mobility and all fundamental breach cases, dealt with risks that the consumer was bound to take under the terms of that contract. Now it tends to be more about deciding who makes the decision whether the company's in breach or not. So we now have a raft of cases involving compulsory dispute resolution clauses, which can be hugely onerous. It's very common to find a multinational corporation requiring that the dispute be arbitrated, that the arbitration be located in a different country, and also that each side agrees to pay the other's legal costs. Well, I don't fancy paying Microsoft, Google, or Facebook's legal costs if I'm arbitrated with them in Seattle or San Francisco. So it seems clear these days that if we can't interpret our way out of the contract, which Bell Mobility did allow, then unconscionability is the weapon of choice. And Justice Cote set out the requirements of unconscionability in Kane Clerical Life Insurance Company. He told me this morning he doesn't take the entire credit for the formulation, but it's an important formulation. What do we mean when we say a contract's unconscionable? It's got to be grossly unfair and improvident. The victim must lack independent legal or other advice. There's an overwhelming imbalance in bargaining power caused by the victim's position, and the other party knowingly takes advantage of that vulnerability. Now, just quickly, one last case on this. In the recent well-known Supreme Court case of Duez and Facebook, this was exactly the issue. The contract provided that all users of Facebook agree to a forum selection and choice of law clause, which required disputes to be resolved in California according to California law. Basically, these clauses are designed to deter consumers from pursuing claims. So, in the Supreme Court case, 3 members of the court said the plaintiff had established a strong case not to enforce the forum selection clause. It was a contract of adhesion. It involved a statutory right of privacy, which the BC Privacy Act states, and it was quasi-constitutional. There was a gross inequality of bargaining power, and it required a California tribunal to interpret the scope of privacy rights in British Columbia. So that was 3 members of the majority. The fourth, Justice Abella, in a concurring judgment, agreed that Facebook could not take advantage of the forum selection clause if the plaintiff could establish the contract was unconscionable. But her judgment suggests that unconscionability required only 2 elements: inequality, bargaining power, and unfairness. So the majority of the court has a somewhat loose test of unconscionability. The 3 dissenting judges, incidentally, emphasized that inequality in bargaining power alone does not mean a contract is unconscionable, and they gave an attributed nod to the Clerical decision by saying really there are 4 elements required, the same 4 elements as the court stated in Clerical. Well, the problem with this is that unconscionability has assumed a much greater role in Canadian contract law in recent years. But what the Facebook case tells us is the courts have not actually settled on what unconscionability means, not what the 4 criteria are. So again, Professor O'Byrne's given me these. There's a recent case on the Ontario Court of Appeal which applies the 4 requirements of Clerical, and a Newfoundland Court of Appeal case saying no, that's way too restrictive. So we really don't know what's going on in that area. And now the last chapter, I hope I'm not over time, deals, I think, with the way stating broad general principles of law has invaded the law of contracts. And of course the famous example of this is the case of Basin and Harinu, a case in which Justice Cote wrote the judgment of the Alberta Court of Appeal. Now, at the time of that decision, what does a duty of good faith and honest performance mean? Well, typically, the common law was recognized in 3 types of relationships. It was recognized in franchise contracts, employment, and fiduciary relationships. And if one of those relationships wasn't present, then there was a duty of good faith only in certain categories of contract doctrine. And they were where the parties must cooperate in order to achieve the objects of the contract, where one party exercises a discretionary power under the contract, and where one party seeks to evade contractual duties. Basin and Harinu did not involve any of the standard relationships. It was close to a franchise agreement and close to an employment agreement, but it was neither. And secondly, it did not fall into any of the existing categories. So the Court of Appeal decision was broadly consistent with the existing requirements. In contrast, the Supreme Court of Canada found the existing categories were just examples of an underlying organizing principle of good faith. It stated that parties must generally must perform their contractual duties honestly and reasonably, and not capriciously or arbitrarily. And that duty can extend not every way, but just incrementally beyond the existing categories recognized in law. The court overcame the entire contract rule by emphasizing the duty of good faith and honest performance is not based on the party's intentions or from an implied term, but it is imposed by the court as a minimum standard of conduct. So that was the nutshell of the dispute. Was it a difficult case? The case was on reserve for 36 weeks. The reasons for judgment consist of 75 substantive paragraphs. So we know it was written at a rate of 2 paragraphs per week. I can manage that. I did it. Justice Brown swearing in, asked Justice Marshall Rothstein, I said, this looks like a judgment written by committee. He roared with laughter and said, behind the curtain, and left it at that. Much has been written about, more words have been spilled about Basin and Harini than any other case in the Canadian Law of Contracts. But it seems to me that what it does is to extend to contract law the generalization of principle that so much marked torts, unjust enrichment, and fiduciary relationships. And the court deliberately chose to state a new and universal principle. So in closing, I think that it's safe to say that the result is contrary to Justice Cote's philosophy of contract law. I regret that Justice Cote is no longer present on the court to provide a counterweight to such trends as we've got a very loose test of unconscionability, and we can't like this rampage around the area of private law, and to think about what the development of a duty of good faith actually means. So, Jean, we will very much miss your presence on the court. We're delighted that you will still be available to us to attend events like today's, to write and to think about the law in an extrajudicial capacity. So thank you very much for your years of service, for your friendship and collegiality over the years. Thank you.
Many thanks, David, Professor Percy. Extremely enlightening comments. It is now my honor to introduce Mr. Doug Stollery, who is the Chancellor, as you know, of the University of Alberta. In addition, he is President of the Stollery Charitable Foundation and a Director of the Stephen Lewis Foundation and Care Canada. In the past, he has served as President of the Alberta branch of the Canadian Bar Association, as a Director of a number of nonprofit organizations, including the Stollery Children's Hospital Foundation, the Legal Education Society of Alberta, the Alberta Law Reform Institute, Victoria School Foundation for the Arts, Grant MacEwan College, and the Certified General Accountants Association of Alberta, as well as the Edmonton 2001 World Championships in Athletics. Mr. Stollery is counsel to the law firm of Reynolds, Wirth, Richards, and Farmer. He previously served as General Counsel and Corporate Secretary to PCL Construction, Inc. He holds his LLB from the University of Alberta and an LLM from Harvard University. Chancellor Stollery.
It's a real honor to be invited to participate in this symposium with distinguished academics from the Faculty of Law. And to the point raised by Professor Acorn, when I use the term academics, I do so in the most positive sense possible. In the brief time available to me, I'd like to address 3 points. First, I'd like to provide a few additional comments to the excellent analysis by Professor Percy of the contributions of Justice Cote to the law of contract. Second, I'd like to speak briefly about the growing isolation of construction law from the judiciary. And finally, I'd like to speak briefly about what I have learned personally and professionally from Justice Cote. To the first point, in response to Professor Percy, I'd like to start with a brief discussion of Justice Cote's views of the respective roles of the parties and the judiciary in establishing the terms of a contract. Succinctly stated, the parties make the deal and the judge enforces the deal that the parties have made, not the deal that the judge believes that the parties should have made. In Benfield Corporate Risk Canada Limited and Beaufort International Insurance Inc., a decision issued in 2013, Justice Cote wrote, Nothing is more dangerous than courts constructing contracts which the parties did not make, or to make the contracts more businesslike or more just, or to make them into what the court supposes would be more businesslike or more just. Adequacy of consideration or the fairness of the bargain, especially after the event, has never been a principle of contract law. The court's function is not to try to inquire into or supply that. He went on to say, counsel and writers sometimes beguilingly suggest that the court's duty is to discover the intent of the parties. Does that mean bypassing the words of a formal signed contract in favor of the parties' competing assertions years later, all encased and cooked in a pastry shell of the trial judge's inferences and deductions? If so, it is wrong. The court is to interpret the words of the signed contract. Phrased in another way and implying a signature Jean-ism, in interpreting a contract, a judge should not turn himself or herself into a pretzel. Now, we've heard a number of references to animals, but you may note here a certain common reference to food. The turkey dinner reference cited by Chief Justice and by Professor Percy, the pastry shell referenced in Benfield, along with the pretzel reference so often used by Justice Cote. Now, when Jean and I practiced law together, I noted that he always kept a packet of crackers in his desk, a desk drawer for a mid-morning snack. This leads me to wonder whether his decisions were often written in the morning, just before the break, when the crackers were top of mind. By the way, in preparing these remarks, I sent this to my colleagues and said, do you think people will laugh at that? Turns out the answer is no. Anyway, Justice Cote's view about the limited role of the judiciary in interpreting contracts is wholly consistent with his view that certainty and predictability are generally more important than the fairness of result in any particular case. I think that it is important to put these views in context. The law of contract involves the enforcement of commitments made by one person to another, and persons, in this context, of course, includes legal entities. The existence of the law of contract has enabled us to move from a society where all persons must source their own food, make their own clothing, and build their own shelter, to a society where persons may specialize in a particular task and rely on others to supply the other goods and services that they need or want. The law of contract is the foundation of our economy and a fundamental basis on which we have evolved as a society. Every time we purchase a bag of groceries, fill up the tank in our car with gasoline, download an app to our phone, or agree to the use of cookies on websites we access, we enter into a contract. Every time we take on a new job, purchase an investment, or buy a home, we enter into a contract. Over the course of our lifetimes, each of us will enter into tens of thousands of contracts, some of great significance, others less. Underlying each of those contracts is the assurance that we will get what we bargained for, or that we will be compensated for the failure to get what we bargained for. It is in this context that certainty in the system as a whole is more important than fairness of the result of the enforcement of a particular contract viewed after the fact by a judicial decision maker. Professor Percy spoke about the transition in the law of contract in Canada from tranquility at the beginning of Justice Cote's legal career to startling change at the end of his legal career. This brings to mind a passage from the book Death of Contract, written by Professor Grant Gilmore in the early 1970s. And I remember this passage because I once used it in an examination I set for my class in jurisprudence some years ago. Professor Gilmore wrote, "We have become used to the idea that in literature and the arts there are alternating rhythms of classicism and romanticism. During classical periods, which are typically of brief duration, everything is neat, tidy, and logical. Theorists and critics reign supreme. Formal rules of structure and composition are stated to the general acclaim. During classical periods, which are, among other things, extremely dull, it seems that nothing interesting is ever going to happen again. But the classical aesthetic, once it has been formulated, regularly breaks down in a protracted romantic agony. The Romantics spurn the exquisitely stated rules of the preceding period. They experiment, they improvise, they deny the existence of any rules. They churn around in an ecstasy of self-expression. At the height of a romantic period, everything is confused, sprawling, formless, and chaotic, as well as frequently extremely interesting. Then, the romantic energy having spent itself, there is a new classical reformulation, and so the rhythms continue. Perhaps we should admit to the possibility of such alternating rhythms in the process of the law." End quote. I think that Justice Cote may best be described as a classicist. In seeking to ensure certainty and predictability in the law of contract, he prefers logic and the application of rules over experimentation and improvisation. It may be that the pendulum of the law of contract is now swinging from classicism to romanticism. If Professor Gilmore is correct, in the fullness of time, it will swing back. Moving on to my second topic, we have also been asked in this session to address the development of construction law, an area of particular interest to Justice Cote and to me. For the reasons I will discuss, this presents more of a challenge. Construction is an inherently risky process. Contractors frequently commit to completing a particular project at a fixed price and by a fixed date. However, ground conditions may not be as expected. Weather conditions may be extreme. Materials, sometimes supplied from abroad, may not meet specifications. Design may be inadequate or late or in error. Labor productivity may be less than expected. Subcontractors may default. Construction contracts have grown in length to address the allocation of these risks among the parties. In some contracts for public-private partnerships, the definition section alone runs to over 200 pages. On a large, complex construction project, disputes about some element or elements of the work may be almost inevitable. Parties to construction contracts cannot practically resort to the courts for the resolution of all those disputes. That is particularly true of disputes that occur during the course of the work, where judicial proceedings to resolve those disputes may interrupt or disrupt the progress or continuation of the work. For all these reasons, contracts for large, complex construction projects almost always include a dispute resolution provision requiring various stages of discussions and negotiations between the parties and leading to arbitration. And for that reason, construction disputes rarely end up in court, including the Court of Appeal of Alberta. These dispute resolution provisions may provide a more expedient mechanism for resolving construction law disputes. And arbitration decisions typically are confidential. Confidentiality may be advantageous to the parties, but regrettably does not assist in the development of the law. However, I'm pleased to note that in his post-judicial career, Justice Cote is now engaging as arbitrator dealing with construction disputes. And so the industry can continue to benefit from his wisdom. Moving on to my final topic, Jean Cote and I first met in May 1972. I had just finished my first year of arts at the University of Alberta and had a summer job at the firm of Honourable, Reynolds, Stevenson and Akers. Jean was a junior partner at the firm. I had shoulder-length hair. Jean had a brush cut. Ever since that day, I have looked to Jean as a mentor, a colleague, and a friend. After I graduated from law school, I joined the firm, and Jean and I practiced law together for over a decade before his appointment to the Court of Appeal. I remember one evening early in my career, I was working late on a project that I thought would never end. Jean came by my office, told me that I had ceased to be productive, and suggested that I go home. When I arrived at the office the next morning, the file was on my desk, and the project was finished. Jean had come in early and completed the work for me. I remember another evening early in my career when Jean again came by my office. It looked like the office of many other lawyers I have known, with files everywhere and papers piled high on my desk. Jean admonished me that I could not, or at least should not, work on more than one file at a time, and that the rest of the files on my desk, and indeed all of the paper in my office, were just distractions to the task at hand. When I came in the next morning, there was only one file on my desk. Jean had diarized the rest of the files for appropriate dates and sent them off to the file room. I discovered that working at a clean desk was indeed more productive. From these and countless other opportunities to work with Jean, I learned the importance of kindness to others and respect for my colleagues within the firm, within the profession, and on the bench. I learned the importance of organization and focusing on one task at a time. I learned the importance of research and logic and clear writing. And I learned how one dedicated person can truly make a difference to our profession and the development of the law. Thank you, Jean, for all these lessons.
Many thanks, Chancellor Stollery, for your insightful comments. I have a question for the panel. Of course, it goes back to the Zine, duty of good faith, the principle of good faith, duty of honesty. And my question is, what do you see as the impact of the Zine on the work of the lower courts, as well as the impact of the Zine on litigation strategy formulated by counsel as they plan their case?
I did a survey for an article exactly 11 months after the Zine decision came down. At that stage, there had been 66 reported cases in which the Zine had been cited, which is a pretty high rate for a case that only came down 11 months earlier. In addition, there have been a number of cases where strikeout applications were brought in which it didn't look very favorable for a duty of good faith, even under the Supreme Court's expanded approach. All the strikeout applications were dismissed on the grounds that the Zine gives an arguable case on this topic. So I think it has very much increased litigation. I've been looking at one very major P3 contract involving a multinational contractor and a very large corporation. Both sides plead absence of duty of good faith and dishonest performance. It's boilerplate in the contractual pleadings, therefore it takes way more judicial time. It's the evidence process that Justice Cote described in his judgment, deploring the addition of terms to contract, implied terms to contract with express terms. It involves exploration of all the negotiations, all the various drafts of the contract, and all the behavior of the parties. So I think it's very time-consuming at the trial level. And unfortunately, the tendency of both parties to plead it in many contractual cases at the moment goes on unabated. So I'm not very pleased with that aspect of it. One can see a nugget behind the duty of good faith, but it reminds me of Lord Macmillan's words, or Lord Hanking's words at the end of Duncan and Stevenson. You know, the categories of negligence are not closed, but we will only extend a short distance to new categories. Well, that worked out well, didn't it? So let's see.
I think the law at the moment is confused, sprawling, formless, and chaotic, as well as extremely interesting, and in the fullness of time, the pendulum will swing to a point where we have greater certainty in the law. We'll move from romanticism back to classicism in the fullness of time.
Thank you, panels. It is now our honor to introduce Professor Emeritus Trevor Anderson. Professor Anderson taught at the University of Alberta Faculty of Law from 1962 to 1971. During his time here, he was involved with the Alberta Law Reform Institute, on committees developing continuing education programs, and in the planning of the Law Centre. He then became a professor and dean of the University of Manitoba Faculty of Law, Director of Education and Venture of the Law Society of Manitoba, and a member of the Public Utilities Board and other public boards and commissions.
He is also an honorary editor of the Alberta Law Review for his significant contributions to our organization when he was a faculty advisor in the very early years of the organization, including when Justice Cote was editor-in-chief. Please join us in welcoming Professor Anderson, who will provide a unique perspective of Justice Cote when he was a student.
I'm greatly honored and pleased to take part in this remarkable tribute to John Cote, more so because it takes place under the auspices of the Alberta Law Review. I have known some of those who brought the review into being, and it was 3 early members of its editorial board, at that time doing graduate work in England, who persuaded me to join the Alberta faculty in 1962, something for which I've always been greatly indebted. I don't think any speaker can match the superb toast that was given to Justice Cote on his retirement by Chief Justice Fraser, but I might perhaps venture a few additional remarks on John Cote, the law student, from the point of view of one of his teachers. Don't mistake me, I never taught John Cote anything. The balance of payments was all the other way. Indeed, we suspected that John came to classes with his lecture notes prepared, which he would occasionally make an approving tick in the margin when or if the professor happened to make a useful point. And indeed that may have been so, because it was rumored that he had this mysterious system of shorthand, probably of his own contrivance, with which he could make virtually verbatim summaries and records. Perhaps in his retirement, he might find further employment accompanying President Trump to meetings with Mr. Putin. For those who are younger than myself, which is virtually everyone present, I should perhaps portray the setting of John's first adventures in the law. The university, of course, was very much smaller than it is now, and a very informal and collegial place. The law faculty was composed of only 6 professors, myself the junior, and had no permanent habitation or home. The offices of the faculty on the second floor of the old arts building, Bill Angus and I were in fact ensconced in cubicles in the Department of English. But the real beating heart of the law school was where the students were. which was on the one side of the lower floor of the Rutherford Library in the so-called reading room, which served also as a clubhouse, a debating chamber, and a general assembly point for the boisterous, and I have to say then almost exclusively male fraternity of law students, and a dark inner room into which no sane professor ever ventured, full of stacks and cubicles. John, I remember, greatly admired the classical grace of the Neo-Georgian Rutherford building, and I can recall how upset he was by the new Cameron Library, of whose architecture he disapproved. All it lacks, he told me, is a flashing sign on the top that says, "Read books, read books." John was in second year when first we met, a member of a very capable class, which included Walter Miss and also Fred Locks, who contributed so much to the school later, and I was absolutely intimidated by the thought of all those sharpshooters just waiting to knock the new bird off his perch. I would have been petrified if I had known then of the extraordinary talents that John was to display. But in fact, John was throughout, as were his colleagues, never less than fully helpful and supportive. In class, he would intervene only to contribute some useful point or reference, to advance the discussion, to refocus us when we were getting off track, and never sought that we could have to embarrass a teacher or a fellow student. He saved other and larger issues for discussion after class. I came to conclude that those post-class discussions were one of the finest and most effective modes of education for me, as for the other students who joined in those discussions, which may, by the way, be one of the reasons why in this building today the major classrooms have foyers in which such post-class discussions can be continued. What most enduringly impressed me about John, the student, one point was that he could read. I mean, really read. He could go through vast amounts of material with intense concentration, analyze the material as he went, connect the dots, keep large tracts of information under control, sort the dross from the gold, and then when he came to write something about it, he had mastered the work, excluded all the irrelevant, weak and wrong points, gone straight to the pith and substance of the matter, and laid it out in direct terms that others could then understand and debate. In his own writing, it was always plain and clear. There were flashes of wit, more than flashes, and occasional striking similes or analogies, but never any straining for effect. The eloquence and the elegance lay in the structure and lucidity of the writing. One saw that in his examination answers and even more in his essays. I suspect much of that was due to his parents, who loved literature and respected historical records and learning. But really, back then, it seemed that really John had just sprung intact from the brow of Zeus, fully formed and with the full armament needed for scholarship, practice, and adjudication. And matching those talents and underlying them and mobilizing them were his incredible energy and industry. And that, in turn, I believe, derived from his extraordinary passion for his subject. For most of us, academics or practitioners, the law is something of a curate's egg, good in parts. But for John, it seemed it was all good, or at least interesting, whether it was substantive or procedural, concerned advocacy or drafting, involved case law or statute. I remember John's excitement one day when he came to tell me that he had discovered a wonderful old textbook called Sinclair on Absconding Debtors, and I'm sure he put it to use. There is a story, I hope it's not apocryphal, that once when John was working for a spell in the law office, his supervisor got a call from the lawyer on the other side of the file and said, about this draft you sent over for us to execute. Yes, is there anything wrong with it? No, it's fine. In fact, it's magnificent. But in this lease for an office in a downtown building, do we really need these 3 pages on ditches and water courses? That would have been at least characteristic of John's thoroughness. In a sense, and I shall abridge this because of our lack of time, my theme today really would be using Wordsworth's language, how the future was prefigured by the past and how the child was father to the man, because all of those characteristics and qualities of John were soon manifested in the work that he did in scholarship and in practice in the years to follow. How he managed to combine them all, I will never know. But it is remarkable that as a second-year law student, he wrote an article on the foundational issue of the law for us. Where did the law come from? The reception of English law in Canada, later supplemented by a further article and an astonishingly complete table of statutes in force in Canada, which today is still the starting point from which to begin. And as a student, he lacked no courage in tackling any subject. Quite early on, he dealt with the continuing issue of the relationship between law and equity, which I happen to notice on this visit to the campus is being dealt with in the current issue, is also being dealt with in the current issue of that other great, the Alberta Law School publication, Canons of Construction. And of course, we all know his contribution, along with Mr. Justice Stevenson, to the vade-mecum of every Alberta practitioner and judge. But I don't intend this as a paean to judges, to John's intellectual powers and productive scholarship, impressive as they are. Just want to say something more about John the person. Perhaps the first thing one has to refer to is his appearance. I mean, even in 1962, when all students dressed more respectably than today, John sometimes stood out for his formality. I can't recall whether he had by then adopted the Trumpian dark overcoat, but he did sometimes appear like a New England missionary among the cannibals. And secondly, there was his kindness and generosity, not just back in the day sharing his work and ideas with other students, but later on sharing with others in the profession his advice based on his own experience on matters ranging from law to legal practice, to the conduct of an office, to the organizations of one's time. And then, of course, there was the extraordinary range of his interests. He is one of the most widely read people one could know. But as his friends know, he has always, it seems, had a special interest in military strategy, the novels of Sir Arthur Conan Doyle, and cryptography and espionage. A very puzzling combination. But perhaps the answer to that puzzle lies to the simple fact that all those involve puzzles, and so eventually involve the satisfaction of a message understood, a picture completed, a picture completed, a story concluded. That love of order, of details properly related and clearly shown in context, is, I think, admirably shown in one of John's lesser-known works, the little chart that he prepared for a history of the Alberta Bar and Courts, in which it showed as it were, the apostolic succession of every judge from the first time that judicial position had been created. It's elegant and simple and complete. I I cannot conclude without at least one glancing reference to John's extraordinary, if not bizarre, sense of humor. A good joke, a witty saying, an outrageous pun may be met by a slap of the knee, a hearty guffaw, more like a hee-haw, and an almost incredible contortion of his elongated frame. But his most jubilant response, almost one might say a fiendish cackle, comes when there has been a successful execution of a long-matured and imaginative practical joke. Beneath the dignity of those judicial robes, there lurked a magnificently juvenile mentality. And I know that his law partners and the Edmonton Bar know of many such maneuvers, and I wouldn't be surprised to be told that even in the law courts, judges might hesitate to open a door without first looking up for a delicately poised bucket of water. But what I remember from school as a favorite recollection is the morning that John came in to the school, chortling uncontrollably. He lived then with some friends in a house in Garneau. Apparently about 3 that morning, a young woman in a sorority house next door had called them up on the telephone to say, "I don't suppose you fellows will know anything about this, but our radiator seems to be playing Beethoven." Another devilish plot fully carried out. Very well done, John, and I hope the future may bring much more music and laughter. Thank you.
Thank you, Professor Anderson, for that enlightening and enjoyable perspective of both John Cote as the law student. Before we turn the microphone over to Justice Cote himself, it is our pleasure as co-editors-in-chief of the Alberta Law Review to formally announce that the board of the Alberta Law Review Society has unanimously passed a motion to welcome him back to our organization as an honorary editor. It has been over a decade since the Alberta Law Review has offered an honorary editorship. We reserve this recognition for only those individuals who have significantly contributed to the development of the review, and Justice Cote certainly fits this description. He was editor-in-chief of the Alberta Law Review from 1963 to 1964 and has published numerous articles, reviews, and notes in our journal throughout all stages of his career. He also acted as a keynote speaker for the Alberta Law Review's 50th anniversary banquet in 2005. He continued his legacy of significantly impacting the Alberta Law Review when his daughter, Anne Cote, continued as co-editor-in-chief from 2000 to 2001.
The first article Justice Cote published with the review, The Introduction of English Law into Alberta, was in 1964. His most recent article with us was published in 2014 in a special issue on the Alberta Court of Appeal centenary. That article discussed the history of the factum in Canada and the origins of written advocacy. Justice Cote remains an important friend of the Alberta Law Review. Going forward, he will appear on all of our publications in a special honorary editor section. He joins the ranks of our other honorary editors, including Professor Emeritus Trevor Anderson, former Dean Wilbur Fee Bowker, and special friend, co-founder, and continuing advisor to the Alberta Law Review, the Honourable William Stevenson. It is now our privilege to introduce the man we have all heard so much about today, the Honourable Jean Cote.
Well, my lady, my lords, eminent chancellor, colleagues, and dear, dear friends, all I can do is offer my thanks. Almost every 3 minutes, this morning have been another occasion for thanks. And to a legally trained audience, I will not simply say thank you 97 times. You can incorporate the other 96 by reference. But I realize a couple of things. The first is that I can't be lengthy today because this room doesn't look right without a blackboard. The second thing is that I have been the luckiest person around because of the teachers and mentors that I have had throughout my career. And I would have terrible difficulties in giving proper thanks to various people, because even if I named 40 people, I would be doing a cruel injustice to the 41st and 42nd and so on, and I can't rank them. So all I can do is generically thank so many good people, far more able and experienced than I, who have gone before me. And I have a cold, my eyes tearing a bit. If I got into that, then I really would be crying, and that would be embarrassing to me. Besides, you heard a number of generic thanks to university teachers to whom I owe so much in the convocation address, and I won't repeat that. But before I impinge on the most sacred thing of the day, lunchtime, your lunchtime, I really think that I should mention one person, picking him out partly because it's over 40 years since he retired, and I fear that a lot of people who have not met him don't know of him, and that's Alexander Smith. Now, you heard me give a brief mention before. I have no doubt that of his generation, Alexander Smith would have been the equal or more than the equal of any law teacher. There is no doubt whatever that you could have plucked him from the University of Alberta and inserted him at McGill or at Oxford, and he would have been the best there was around. In Alberta, we have learned to downplay what we have, and we don't sometimes realize that we have the best. And I just want to tell you for 2 minutes how he became that way. He was a high school student in Vermilion, and he was so practical, and he so liked the outdoors and hunting and fishing that he dropped out of high school to farm. And after working on digging a well one afternoon and going into town for supplies, he got caught by a thunderstorm coming back with a team and a wagon. And he got soaked and got a chill and got very sick, and he got sicker and sicker, and he was on the floor beside the kitchen stove, and when the smoke cleared, his legs wouldn't work. The doctor came, didn't know what the problem was. They got him into University Hospital. It was polio. So, no good as a farmer. Only thing, the family were Scottish. He'd come to Canada in more recent years. He decided the only way to make a go of it, to earn a living, where he didn't have to walk, was to become a lawyer. So he went to the U of A, and they wouldn't excuse him from phys ed. There were a lot of required classes, and he could barely get up a pair of stairs very slowly by using 2 canes and having braces on his paralyzed legs. So he had to work botany into the curriculum. did very well. The botany people tried their darndest to talk him into grad work, but he didn't. He went into law school, and he was in that famous class of 1940, the Lex Nova class. And he had just graduated when the war got serious. Milner Steer shrunk from being a big firm of 6 or 7 or 8 lawyers down to a small group. Their business got extraordinarily heavy, and he was one of the few people who was carrying on that practice during the war. And everything was governed by wartime regulations. It was just awful. And occasionally he'd get sick. At the end of the war, when Wilbur Boker suddenly had a few weeks to resurrect the law school and get a huge class of veterans going, he brought Alex Smith over, and then Alex Smith twice went to Stanford and ended up with an SJD almost unknown in those days. Well, Alex Smith was the intellectual successor to Dean Weir, who was undoubtedly one of the greatest legal minds of that generation. And Alex Smith carried it on. And what motivated him? He was a physical, passionate man, imprisoned in half a body. And he had such energy, seated there at an old dusty desk with one paralyzed leg pulled up onto the desk, and he'd ask, "You, Smith, what's the answer to that?" And somebody answered. Bang would hit the desk with the cane. "No, it's this." And then he'd ask you, you read what Lord Atkins said there, and you'd read it out, and he'd say, "Ah, golden words." Now, I could go on for the rest of the day. I won't. But he taught the most difficult courses in the law school. He had the depth of analysis, and I assure you that when you learned the law of mistake in contract, you got more analysis, more integrated analysis than you would find in any of the textbooks, British or American. He was unparalleled. And there are classmates of mine here we went through law school together, and we all know what a power Alex Smith was. And I cannot stop without calling him to your mind. But I thank you deeply.
Before ending this wonderful symposium celebrating such a wonderful man who has contributed so much to the legal community, we just want to offer several thanks to some important people who have made this symposium a reality. First and foremost, thank you to the Honourable John Cote for being here today and for your contributions to the University of Alberta, the Faculty of Law, and the Alberta Law Review, and indeed the wider legal community. We're delighted to celebrate you and your many achievements today.
And thank you to everyone who braved the weather to participate in the symposium today. But this event would not have been possible without the efforts of many, many people. First, thank you to Professor Annalise Acorn for being the driving mind behind this great event. Thank you to Dean Paton for his support of this event, and to faculty members for rescheduling classes and participating today. And thank you to the rest of the planning team, Alex McKenzie of the Alberta Law Review Special Projects Committee, and Faculty of Law staff, particularly the communications team, including Sarah Foe, Priscilla Popp, Tim Young, Helen Matella, and Director of Communications, Tara Blasco-Rye, and also in advancement, the Assistant Director of Advancement, Jillian Reed.
We also want to thank all the speakers today, the panel members, and all the moderators. Again, we want to remind everyone that the panel discussions will be published in an upcoming issue of the Alberta Law Review to commemorate this event. When the discussions are published, we encourage everyone here today to freely access them and distribute them far and wide so that we can show the world Justice Cote's significant legal contributions. Thank you as well to our many student volunteers. No event of this size and caliber can run smoothly without your extra hands behind the scenes.
And finally, thank you very much to Reynolds, Merck, Richards, and Farmer LLP for providing the refreshments during the break and for providing the lunch for this event. That lunch is now available outside of this lecture hall, so please exit through either door and enjoy. Thank you.